When you hear the tone, you will be the fifth person to join the meeting. Joining the meeting. Joining the meeting.
Jared Barrett.
Joining the meeting.
Laura Petzel. Oh, there's the Microsoft support number.
Joining the meeting.
Dean Crane.
Joining the meeting.
Todd Hathaway.
Some other house-taking notes here. The ladies' room is right here. The men's room is around the corner. Somebody can help you find it if you don't. It's basically on the other side of the floor. This program is being webcast. The slides are there, and you'll hear the audio of the speakers. You won't see the speakers live on video. It's just going to be the slides as well as the audio. And we hope to make it available for streaming later on as well. We don't know if it'll be offered for CLE credit later on or not. That's something the Bar Association has to decide. This program is jointly sponsored by the IEEE, the Washington State Patent Lawyers Association, the University of Washington, Perkins Coie, where we're hosting it. Some of my partners are in the room with me. I'm an attorney and a partner here at Perkins Coie in the IP section, and thank you to my partners and to the firm
Joining the meeting.
letting us use the space and for the breakfast and lunch. Keith, did I forget any of the other sponsors? I think that's the full list, right? No. Okay. So I'm going to turn it over to Keith Grislak. Keith is a practitioner here in Spokane, and he's also got a fancy title at the IEEE that I've forgotten the name of, but he'll mention it. Okay. And then Keith is going to introduce the speakers, and we'll you have the agenda with you as well. So we're going to have a few breaks, and we'll have a lunch break, and here's Keith to kick it off.
Thank you, Rajiv. About a year ago, Rajiv, Dave Powers, and myself were talking about AIA, and we kind of mutually decided that we needed to have a developed program last year on this topic. I'm actively involved in IEEE. I'm in private practice in Spokane, Washington. I'm currently on the board of directors of IEEE USA, which is a nonprofit with about 210,000 members. So I do a lot of things that a patent lawyer probably wouldn't be doing. I end up taking a lot of calls and doing a lot of interviews on behalf of the organization for STEM worker issues that include immigration, H-1B, visa, et cetera, and a lot of legislative efforts. A lot of people don't know this, but IEEE USA has had an intellectual property policy committee for about 35 or 40 years. And I've been actively involved in that committee since 1993 when I was practicing patent law in Ann Arbor, Michigan. I ended up chairing that committee through 4 years of the push to get AIA through passage in the House and the Senate. And a lot of those committee members were very actively involved. And last year when we decided to have a program, IEEE has an initiative through their international organization, an IP Professionals Initiative, and I co-chair that. And the effort was to try to help educate our members to IP policy issues and changes in IP law. And it's an outreach to the IEEE sections, but it's also an outreach to the bar, and it's kind of a collaboration between the IP lawyers and the inventors. So if any of you are really interested, this is my plug. You're interested in hanging out not just with lawyers, but also technical people. We've got some really exceptional and unusual people that are involved in our listservs and our collaborations, both on the policy end for the Intellectual Property Committee and with respect to outreach for education for our members. The last presentation I gave was last month. It was the IEEE section at Westinghouse, where they're designing all those nuclear power plants that are going into China. And a lot of the content that we've been presenting on our programs has been geared to raise issues that are really more significant with small businesses and small entities. But I got to tell you, after talking to House Counsel Westinghouse, came up to me afterwards and said a lot of these issues that you folks have developed are critical issues in a corporate entity. These are things that I think a lot of corporate counsel need to be thinking about. They're significant changes, and the speakers that we brought last year and the speakers that came this year have participated in IEEE events. To the extent that we can, we're going to capture this event and make it available later. Our George Mason event was videotaped, and the editing is done, and it should be up in about a week. So if you can get on the search engine and type in IEEE IP Professionals, you'll find our website, and there are a series of presentations. Last year's George Mason event's up and available. Rob Stern participated in that. David Bounty participated in that. This year we added Rick Nyfield, he made a phenomenal presentation. We got a lot of excellent feedback. So I asked Rob and I asked Rick to come to Seattle to help proselytize these changes and the things that we need to be doing so that at least IEEE members can see what they need to do to change their business practices. So again, thank you. I'm going to very quickly go through my presentation. I really just want to point out a few things that I know are not in other people's slides.
Joining the meeting.
Excellent. For those of you that are online, there's a Q&A button that you can click on if you want to ask a question, and we're going to manage asking questions of the speakers today. So I would like to actively encourage that. We did this at George Mason last month, and it worked out quite well. And even if we can't answer it now, we'll make an effort and attempt to get those answered and get it back to you. So as long as we can contact you, I would encourage you to ask those questions, and at a time appropriate, depending on the speaker, we'll interrupt and ask the questions, because I like the collaboration. I want to ask a few questions before I begin, and I'm just going to fly through a few things on my deck so I don't take time from other speakers. How many of you have really looked extensively at the provisions that were adopted this past September 16th in AIA and are comfortable in understanding what they mean? Let's see if any hands. Good. One of our speakers raised his hand. That's a good sign. How many here are comfortable with the new 102 that will be adopted on March 16th under First Inventor to File? Anyone here attempted to read 102A and 102B and discern the distinctions, other than Dr. Nyfield back there? He's raising his hand again. How many of you are comfortable with what Rob Stern is going to refer to as contested patent practice? That thing that's between patent prosecution and patent litigation, which, by the way, is already adopted. Has anyone here spent a significant amount of time looking at the potential possibilities in your practice and the ramifications to your clients? Okay, we've got a hand. My sense from the presentations I've made, and I've made about 7 or 8 this year, the patent bar is way behind. And there are a lot of things that need to be done. And I will share one thing with you from a private meeting that we had in D.C. with somebody at PTO who's retiring and expressed their glee in retiring. This is a two-way street, particularly with First Inventor to File. It's coming on March 16th, and things are going to change substantially. And it isn't just about the patent bar understanding how to practice. It's also going to be about the patent examiners. So you need to think about the consequences of the quality of office actions and what's going to happen next spring.
Joining the meeting.
I would take it upon yourself to really put some time in between now and March 16th.
Joining the meeting.
Because it doesn't matter what resources you're given, what management structure you have, you cannot make this level of changes and get things done perfectly. So we're going to see it from the patent examiners and the patent bar collision. And I think it's incumbent on us to do our part, which is to understand the ramifications of this piece of legislation, which is really the biggest thing in more than 140 years. This makes the 52 Act look relatively insignificant. So, and to the extent you're going to hear from Dr. Ron Katznelson, who's done some significant work about a number of concerns that we should be thinking about with our clients and how they do things and how they address their innovation process. So this is the history. The critical date everybody knows by now, I hope, September 16th was passage of this bill. I think everybody here understands that. And I'm just going to go over a short summary. These are all the sections of the bill. I just threw this deck in.
Joining the meeting.
Go back and look at them if you have a question about the section during any of the speakers. We've all heard a lot about the satellite offices, but there are a lot of other provisions in here that we haven't thought about, I think. And this is the most important thing. The red section here are all the sections that were adopted on September 16th. So everybody's heard about the issues with inventor oath and declaration. There's some questions about magic language and whether or not some terms should have been taken out of declarations. If you've been following the blogs, be careful with your oath and declaration. Post-grant review, inter-parties review, PTAB. Rob got an excellent presentation. He's got an excellent 2-volume book that's out, and I'm sure he'll plug it. If he doesn't, I'm going to plug it right now. I would advise you to consider acquiring a copy because the timelines are very challenging. And if your employer or one of your clients comes in with one of these things, you're going to wish you had something at hand that's quick reference because it's challenging. And that is why we asked Rob to come here today to speak. And our feedback from his George Mason event a month and a half ago was exceptional. So start thinking about those issues now. There aren't answers to every issue. The strategies that you might use are multifaceted, and I don't think anyone has optimized yet, and most haven't considered. So how do you deal with this offensively? How do you deal with it defensively? As lawyers, we should be thinking about these things right now because when they land in our lap, we're not going to have the time to do it justice. Okay, and one of the things you're going to get from Dr. Katznelson's presentation, I don't want to elaborate, but this is the question the patent bar is asking, is there a grace period? March 16th is coming up quickly, and you're going to see Ron discuss some of the issues. To what extent can your client accelerate technological development? To what extent can they file cases? To what extent can they address continuation and divisional cases? To what extent might an amendment made on March 16th or later potentially affect or taint a family? Because there are issues as to what prior art you're subjected to. Public use and on sale, you're going to hear, is worldwide. So that might be pretty significant, and those facts might not be in the file that you're looking at as you're looking at your client's product development. You better
Joining the meeting.
Whether or not your case falling under first inventor to file is a dead case or a legitimate case that they can file. You better understand that now because it changes on March 16th. And to the extent that you can advise your client to do something before March 16th, you need to be considering it. You don't need to be sitting at home on March 15th trying to figure this out. I think that's probably why most of you are here. So I think Ron does an excellent job on that. I'm going to skip over a lot of my slides. I like showing this one because, you know, we had more than just litigation to test patents. We had a couple of provisions. We now have a couple more. And Rob's going to do an excellent job covering those. So multivariate strategies could be used
Joining the meeting.
offensively and defensively.
They know.
So these two slides, these are good things, and you know, these are good things I think in AIA. False marking. Oh, these are significant tools that patent lawyers are using, and I think they're very good features and skills. I also like to make a note in my own presentation, but I'm going to repeat it here because I think repetition is necessary. Failure to disclose best mode from being used to invalidate an issued patent. So claims will not be invalidated because of a lack of best mode. How many of you here believe how high best mode? If your best client comes to you or your employer comes to you and says, we've got a wonderful trade secret we would like to keep. And it's our preferred implementation. Have each of you thought about how you're going to...
Joining the meeting.
If your client asks you, we want to keep a trade secret, yet we want to file a patent application, you won't invalidate the claim, but the USPTO still has a duty to only issue patents that satisfy the best use requirements. So invariably, some of you are going to be asked by clients to keep a trade secret. In fact, one of the significant things. Just a second. Somebody who's webbed in has something on, and you might want to put your speaker on mute. So this is a significant thing that I think many practitioners eventually are going to be asked by one of their clients. You should be prepared in how you respond to that. Ridiculous. Don't make the mistake of thinking that, well, your claims won't be invalidated, so let's go do it. This will develop. Yes, for everybody on the phone, please mute your phone. We're getting feedback here in the conference room. Thank you. Right. So that's a very significant problem, and we've had some deliberations amongst our subcommittees trying to understand to what extent can you keep secrets, because certainly AIA is a change. It's a shift from do we patent or do we keep trade secrets, and there's a shift in balance. And some people are going to make business decisions to change what they do. And the patent bar has been put in an interesting situation because PTO has a duty only to issue patents. Will OED do something? We'll see. But don't go running off thinking best mode is no longer an issue and your client asks you to keep it. Why not? It doesn't invalidate the claim, so it puts us in an uncomfortable position. But you should be thinking now about these things so when your client asks you, you know how to respond. Okay, and we're going to hear a little bit about fee setting authority, Dr. Katznelson's last two slides. There's a publication, DNA is publishing, I believe today, I think it made the cutoff for today, and next Friday, a two-part piece on Dr. Katznelson's views on fee-setting authority. I'd ask you to look at it when it becomes available. He may comment on it during his presentation. It's a very exhaustive piece of work. I went through several edits of it, but it's a very thought-provoking analysis of fee setting, and the issues are, can you shape applicant behavior? You know, was it Congress's intent to shape applicant behavior by setting fees? And you're going to see a few slides in his deck. I'm going to skip through this. I think these things are already covered in a few of our presentations. And for those of you that didn't raise your hand, which is most of you, AIA no longer mentions in this country. So public use and on sale worldwide. That's the critical issue for March 16th. I'm reiterating this because it's been an important point that's come out of the presentations that we made. It's been a discussion point of a lot of practitioners. You need to be thinking about what that means. What can you do for your client or your employer right now in developing technology if it appears that a public use or on sale causes a problem for you if it's worldwide? And the law is going to have to develop in this area, because if you have a great patent and someone in China asserts that your patent's invalid because someone did something in Malaysia, there was a public use in Malaysia and they signed a declaration, how are you going to avail yourself of their legal system? How are you going to show the truth and veracity? Their assertion that your patent is invalid using a public use or an on sale that was in some third world country that really doesn't have a legal system that is fair to foreigners. So the law is going to develop in this area. I don't think a lot of U.S. practitioners have thought about this, but it's an important consideration to the extent that you're concerned about that and you have intellectual property that you can file now. You should understand what you need to file, if your client can accelerate their technological development to file by March 15th, and what it means to file claims in that family tree after March 15th, as far as tainting them and potentially bringing them in to first inventor to file, which would suddenly open you up to worldwide public use and on sale, which may mean that you have a dead patent, potentially. So these are all critical issues in practice that we are finding out. The folks that we present to call us up, email us, and say, wow, I started thinking about this. This is a concern. So you can do something about it now. It's going to be difficult on the evening of March 15th when you pull everything out and start trying to figure it out. So please don't do that. Okay, there's just a few other things in here. I'll go back.
All guests have been muted.
Thank you. Okay, so you can look through my deck. This is really a 3-hour presentation, but there's two things at the end here I want to cover. Dr. Katznelson has a developed slide off of this. How many here have a cable modem in their house or at work? Okay. Ron won't say it, but I'll say it. He's probably online listening. Ron was on the DOCSIS work group. And he started a company, Broadband Innovations. And I met Ron because of activity on Capitol Hill. For those of you who don't know, Rob Stern was actively involved and brought into discussions with Congressional Staff Council on the issues of this contested practice and what was going to happen under AIA. So most of us met in visits on the Hill or crossed paths as this legislation percolated for about 7 years. I know of 2 cases where individuals have looked back at their companies and said, what would I have done if this had been AIA? And so these 2 slides that I'm going to show you, I've gotten a lot of feedback on. Ron's not using the slide. He's got a similar slide that lays it out a little bit differently, but it begs repetition. This is what Ron did with Broadband Innovations. Broadband was acquired by Motorola eventually. And Ron raises the question, if I had been operating under AIA, I might not have made it out to this point. And what you're looking at is the one patent application that he filed in the first 3 years. And the green dots are all the iterative things that he would be doing on a first inventor to file system. Remember, conception no longer matters under first inventor to file. There's no placeholder anymore. The thought process that we were trained in as patent lawyers, it just doesn't matter that you conceived of something. All that matters is that you file. And so for those folks that are doing iterative technological development, what we like to refer to as Edison's light bulb, where almost 2,000 iterations were tested and tried before a working, viable, final implementation was arrived at, they raise concerns when you wait to glom together a series of iterative innovations. And they beg the question, should we file? And the question here is, under AIA, you're more likely to have to consider filing all of these. Do you have the resources? And the analogy that's worked really well was one that
Joining the meeting.
Carl and I developed. And it was used a year ago at George Mason, and we got a lot of feedback on it. And it's old patent law. The inventor's driving a car, and the patent attorney's sitting in the back seat of the car. You know, quarterly, you do a patent review. So that patent attorney will periodically tap the inventor on the shoulder and tell him, wait a second, we've got to file a patent application. We've got to stop the car, we've got to file a patent application. The best way of explaining this slide is, under AIA, you really need to put your inventor on a leash. That car now is a driver's ed car. And the inventor's still driving it, but the patent lawyer's sitting in the passenger front seat and has his own brake pedal. And he's going to periodically have to constrain the inventor to consider this issue. And when I spoke at Westinghouse, one of the things that came back was, wait a second, this applies to us. This isn't just startup companies like Broadband. We can't get an increase in our budget. We do quarterly reviews. How are we going to know we hit each of these events? Because one of these, as you'll see in my next slide, this is Steve Perlman. Steve used to be a group president at Microsoft. And Steve was very helpful in raising concerns and considerations in AIA as it percolated through Congress. And he went back to one of his companies, and I've shown this slide a few times in Washington State, so you may have seen it before, but Steve makes the point that this is spatial capture. This is what won the Academy Award on Benjamin Button. And they are trying to figure out how to capture the facial features on actors and actresses. Every one of these
Joining the meeting.
initial idea.
Ron
And if you've got to race to the patent office and file on each of these, how do you get the budget? How do you get the inventor time? At what points do you make these filing decisions? And AIA begs you to consider filing more early, filing more often. And if you don't have the budget to file on every one of these, what if you just skip one? And what if that one you skip is that one? Because this is all that Steve really needed in the end, were these green paths. And so this is a challenge that our practices face. And it's not just those of us in private practice that may have a startup client that has limited resources, but it's those of us managing portfolios inside companies. Because If we have to sit in that driver's ed car with that inventor and monitor his every step, that inventor is usually trying to engineer. Spending so much time with the patent lawyer can get a little bit unmanageable. So we need to find resources to manage our inventors. And this is going to be the challenge of AIA. And I think if these two slides stick in your head, nothing else does, these are takeaway points that you need to be thinking about now with your clients, now with your company, to ask yourself, how do we change our business practices? And I know Ron Katznelson is going to speak a little bit more about some of those concerns as he sees them. There may not be one solution, but these are the kinds of things that we need to address. By the way, this is a nice aside. Pull it up in my deck later. A few patents that Dr. Katznelson looked at backwards and asked this question: would they have been valid under AIA, under first inventor file? And this is a kind of, one last point. So AIA, biggest change in patent law in over 140 years. But what's interesting is this is all continuing patent reform. This week we heard about technical amendments. 2 days ago there was a bill passed. The Hague Treaty was actually passed. It should be signed, I would expect, in the next week. But I really have gotten a lot of feedback on the SHIELD Act, number 4. How many here have heard about the SHIELD Act? Okay, 2 hands. How many here have ever heard of loser pays legal system? Okay, hands are going up. Tell all your friends that are not patent lawyers about the SHIELD Act. This isn't loser pays. This is better than that. This is one-way loser pays. If a patent holder asserts a patent and they lose, they pay. Somebody challenges your patent, it's one-way loser pays. So you should be monitoring the SHIELD Act. Please, if you have lawyers that litigate in other areas, warn them, because this will spread like wildfire. So pay attention to the SHIELD Act. And that's my summary. We are going to, for those of you online, I think it's been changed, but we are going to change the order of our presentations. Rob Stern had asked if he could come early, and Dr. Katznelson is going to present afterwards. For those of you that haven't had a chance to look at the deck, Rob was gracious enough to come out to Seattle again. He did an excellent job at George Mason. The feedback that we got, we had about 300 online participants, probably more actually, registered online. This is an area of the law that is very significant and is underappreciated. And we are all going to watch this develop, and Rob is here to really advise us to get going. And I'd like to introduce you to Rob Stern from Stern Kessler. Rob played a significant role in this.
Good morning, and thank you very much for the opportunity to be here today to talk about the new contested proceedings under the American Invents Act. Patent Office litigation is the title that I have selected for my 2-volume book, which is here, published by Thomson Reuters West. We passed around the flyer that gives you a little bit of information on how to order it. It published about a month and a half ago. It's the first book on the topic, 1,025 pages, 23 chapters, and it deals with all of the contested proceedings that we're going to be talking about today, as well as the interfaces between these contested proceedings.
Joining the meeting.
And the district courts, the International Trade Commission, APA actions brought to the district courts, and appeals to the Federal Circuit, and the international context, because we're operating now in an international environment with comparable proceedings. And as we know from the cell phone wars, for example, this is truly a global play. I will take the book to the first table over here and ask people to pass it around while I'm giving my presentation. So I have presented on this topic since September 21st to probably 2,000 patent lawyers and other patent professionals and interested people at a series of events like this one. I was at the Advanced Patent Law Institute in Palo Alto yesterday on a panel with Chief Judge Smith from the Patent Trial and Appeal Board, as well as 2 other practitioners. And that was a very well received, but frankly, a very eye-opening discussion with our Chief Judge of the board, because I was asked by him if I was taking his deposition halfway through the presentation, because I was asking many questions that many of us have, and frankly, I don't think the Patent Office has figured out a lot of the answers. And I don't know if we have Judge Tierney here yet, but I know he will be speaking later today. So let me start by saying that this is completely a new ball game. Yes, I would agree with Keith that this is the largest change since the 1836 Patent Act. It's more significant, I would say, than the 1952 Act or even the creation of the Federal Circuit. And the reason for this is there are so many variables that a patent owner has to now deal with in order to go from inventing to patenting to getting the exclusive rights enforced that the Constitution created. And so for all of us that have to deal with the actual work of the patent system, you're going to need to be concerned and frankly, at least at a working level, knowledge of these new contested proceedings, because even if your focus is on licensing or straight district court litigation or ITC litigation or prosecution or strategy and tactics or monetization, you're going to need to deal with these new contested proceedings. So what was the idea that was sold to Congress and to others about this new contested world? And the idea was that we were now going to bring back to the Patent Office the issue of whether the patent should have been issued in the first place. And we're creating what would be described as a serial system where the patent issues, the patent is enforced, it's now taken back to the Patent Office, the Patent Office does its thing, and if the patent satisfies that test, it goes back to the district court, or maybe even the ITC would stop its proceeding. No one knew when they were drafting the legislation, and then it would go back to the tribunal. And the idea, of course, being that the Patent Office was the best one to do this kind of determination. And in talking with Joe Mittal a lot during the 7 years that led up to this law being passed, I can tell you that there was a lot of appeal in Congress to this idea of let's streamline the process, let's put the critical decision-making where it really belongs, which is at the Patent Office. So the idea was to have this serial system where the issue of validity or patentability was going to be retested at the Patent Office and then go back to the enforcement tribunal. But is that what we're going to see in this new world? Is it really going to be a serial system very akin to what we see in Germany, for example, where most of the patent litigation in Europe currently is conducted, where you have regional district courts dealing with infringement first, and then the federal patent court in Munich dealing with validity second? Are we going to have a serial system in the United States, one that we've never seen ever in the history of the Republic? Or are we going to continue to have the parallel universe that we saw emerge with reexamination starting around 2005, where, as many of us know, you would go to court and then the parallel proceeding would start at the Patent Office with the reexamination, and from there the reexamination would be running in parallel with the district court or the ITC, and they would eventually meet up at the Federal Circuit, and we would have some of these anomalous results where the patent would be enforced. There would be a large jury verdict, which would then be overturned by a win by the challenger in the reexamination world when the reexamination caught up to the parallel proceeding. So the question we all need to ask first is, have we gone to a serial world, or are we still in a parallel world? And the answer is, it depends. It depends on whether you're in the ITC, where I would submit it's going to be continued parallel world, though we're not certain, or are we in the district court, and in the district court, depending on the contested proceeding, and we'll talk about which ones will force stays more than others, it's quite possible that in a fast-track district court, particularly those in the patent pilot program, the district court judge may decide for many good reasons why they will not stay their proceeding pending completion of the proceeding at the board. Now, yesterday I asked Judge Smith, Chief Judge Smith, about this as part of my deposition, and he said that the Patent Office had been meeting with some of the judges in the patent pilot program. And you know there's 14 districts in our patent pilot program that have opted in, plus we have the district in Delaware and the district in the Eastern District of Virginia who have not opted in, but who have a lot of patent cases pending, and historically have heard a lot of patent cases. So you have about 16 courts in the United States, the Northern District of Texas, Eastern District of Texas, Northern District of California, Central District of California, Southern District of California, and others that have opted into this patent pilot program. And so these judges, more than others, because they're the ones who want to do these cases of ours, they're the ones who really like the patent cases, and there's a group of judges that really do. They're scratching their heads saying, and this is based on a lot of off-the-record discussions I've had with them, they're saying, why would we want to stay our proceeding? Why would we? Is it a good idea for us to stay our proceeding? It's justice delayed, justice denied. And there's many things about why we would not want to stay our proceedings that we're going to take into account, and we may not stay. And I know there are cases now where stays have not been instituted. Now, Chief Judge Smith, when I asked him this question, said, well, we're suggesting strongly were his words, to the district court judges that they do stay because we will be cheaper and we will be faster and we will be better. So let's talk about that. Faster, cheaper, better. That was the promise of this new system. That was the promise. It was going to be faster, cheaper, and better on the issue of validity, which is actually at the Patent Office patentability, not validity. And why is it patentability and not validity at the Patent Office, unlike the similar and identical challenge of the claims in the district court? Because of several reasons. First of all, there's a different claim construction rubric used in the PTO, and Chief Judge Smith confirmed yesterday that they are going to not deviate from that, and that's the broadest reasonable interpretation of the claims in light of the specification. Now, this is typically a broader construction of the claims than you would get in a typical Markman hearing of the patent claims in an enforcement action, whether it be at the ITC or at the district court. So the PTO is adopting a broader construction of the claims typically than you would have for the same claim in the enforcement action. And the reason that is always stated for doing this is that you can amend claims and add claims in the reexamination process and now in these new contested proceedings. But as many of us know, as a practical matter, the moment you start fiddling with your claims at all in the Patent Office in this parallel world, it's going to have huge ramifications in your enforcement action in the courts and could extinguish damages, for example, and also produce very anomalous results because the district court claim interpretation in the Markman process and being used in discovery has changed because of what's happened at the office. So as a practical matter, many people would argue that it's not possible to really change your claims in these proceedings, particularly if you're in an enforcement mode already. In other words, you're in the district courts or in the ITC. So the broadest reasonable interpretation in light of the specification rule is challenged by many because if there is a Markman ruling, the PTO, as the judge said yesterday, is not bound by that Markman ruling in these parallel proceedings because they're dealing with patentability in the office, whereas the court's dealing with validity. So you're whipsawed as the patent owner, arguably, because if the Markman is narrower than your broadest reasonable interpretation, you're not going to get the benefit of that at the office, so you're going to have this crazy situation where claims are going to be evaluated differently for patentability than they will be evaluated for infringement, which, as we all know, is one of the canons of claim construction in the district courts, is you're going to treat the claim construction the same between validity and infringement. The second big difference, of course, is the burden of proof. In the district courts and the ITC, it's clear and convincing evidence. Whereas at the Patent Office, it's preponderance of the evidence, and essentially, once the proceeding is started, it's instituted, then the presumption really is gone, because at this point in the process, the patent owner is defending her claims in these proceedings as not being obvious or anticipated by the references or other art that's being asserted in these proceedings. So you don't get the benefit in the PTO of this burden of proof that you have to satisfy. And another point that we're going to talk about in a minute is the difference in the way obviousness is dealt with at the Patent Office. Because in front of a jury, you can present the story of the invention with its full detail, whereas at the Patent Office, as we'll talk about, the Patent Office has very great difficulty figuring out whether the evidence should be looked at all in terms of non-obviousness, the so-called secondary indicia or objective indicia of non-obviousness, because of their requirement of a strong nexus between the claims and the evidence in order for the evidence to be considered at all. So we have a much different system between the office where they're assessing patentability and the courts and the ITC where they're assessing validity. So with that set in mind, understand that when we talk about patent office litigation here and around the world, we are really focusing on the central issue of whether the patent is valid. That's the real issue that we now have. It used to be that validity was a non-issue as a practical matter in many district court cases because of the clear and convincing evidence standard and the way the jury system decision was reviewed by the Federal Circuit for substantial evidence. But now, with this patentability challenge in the USPTO and with comparable challenges, for example, in opposition in Europe and around the world, I would submit to you that patents have become much weaker globally just because of that. So the first promise was that it was going to be faster. It was going to be faster. And why? Because the statute recognized, based on conversations that I and others had, that the inter-party reexamination process was taking 5 to 8 years from the time that the reexam was filed through the central reexamination unit, then on to the Board of Patent Appeals and Interferences, and then on to the Federal Circuit. And there were remands going from the board back to the CRU in these inter-party reexams, as many of us in the room know, because we've been in them. And we all know that these inter-party reexams take a long, long time. So the big problem with the inter-party reexam process was not the estoppels that many people had been afraid of at the beginning when they were first created back in 1999, but in fact it had to deal with the fact that they took so long, and they essentially gave the accused infringer a second bite at the apple, because even if they lost in their faster enforcement action in the district courts, they would get a second chance to take the patent down when the inter-party re-exam finally made it to the Federal Circuit. So the idea with this new regime was we're going to do it faster by creating statutory requirements that cannot be deviated from as to how quickly the proceeding has to be completed. And the Patent Office is seized on this issue as being central to everything they've done with the new rules, the way the rules have been implemented, the way the procedures are going to operate. Everything is driven by the statutory requirement. It's not a mandate, but it's a requirement that these proceedings be completed within 12 months from when they're instituted. 12 months. Now, you think about the International Trade Commission 337 proceedings, where the complainant has months and months and months where she can prepare her 337 complaint. Once these things get instituted at the PTO, once they get ordered, as the word is used, they have to be completed within 12 months, 18 months in exceptional circumstances. But from everything we see, that's probably not going to happen unless we have multiple proceedings consolidated into one proceeding, and then maybe we will get the 18 months. So 12 months from when the trial is ordered at the PTO to a final written opinion from the board. And at that point, and we'll talk about this some more, that's when the estoppels kick in now under this new regime. So that is fast. 12 months is fast compared to practically every district court in the United States, including the Eastern District of Texas. 12 months from the filing of the complaint to the decision by the court would be a very, very fast track in the district court. So the idea was, by creating a very fast system of the PTO, it would encourage the courts to defer to the PTO, save their resources, and then the case would get back to them only if the patentability challenge was met by the patent owner. So that was the promise of faster. Now, we don't know how this is going to work. We don't know how this is going to work because how many people in here have ever been involved in an interference? Okay? Well, as many of you know, the interference bar is out and about, according to Judge Smith, telling everybody, if you've never done interferences, you shouldn't be doing these proceedings.
Joining the meeting.
Interference attorneys who know what we're about to enter into, because the whole new process as implemented by the PTO is very akin to the way interferences were instituted over the last many, many years. Now, he challenges that and says that interference knowledge is not necessarily going to make the day, that if you're a big expert on interferences, great. But that's not the only skill set that you're going to need in these new proceedings. And of course, you know, the big question is, who's going to do these proceedings best? So interference is the model in many ways as a way for the Patent Office to get this job done quickly by the one-year deadline set by the statute. But they also looked at the International Trade Commission proceedings to see how they were done. And I can tell you that these proceedings are much different and, frankly, much more summary, much less discovery, much less opportunity for oral argument and cross-examination, et cetera, than you would get in the ITC. So for the ITC practitioners here, that's going to be a skill set that's going to be very, very important to doing these proceedings. I would also tell you that the proceedings are going to be in very much a patent office world. So for all the people here with registration numbers like myself, you are more important now. Don't let anybody fool you. We are in the patent office. We're not in the Southern District of New York doing rock and roll patent litigation where everything goes and everybody is allowed to do everything, essentially. Patent office is not going to put up with that kind of BS. They've told us we will not have litigation tactics conducted in these proceedings. So for the patent attorneys in the room, your registration number really matters. It really matters. Now, there was a move afoot to say that only patent attorneys would be allowed to practice in these proceedings. I think, was the first person to submit comments suggesting that should be the case. because I have a registration number and I'm proud of it. And I'm not afraid to say that the patent practice is much different than the district court practice. And knowledge of the patent law, knowledge of how the office operates, knowledge of the way evidence is treated matters. So patent attorney expertise matters, but the patent office didn't go that far because they were being lobbied by all you trial lawyers in the room who said, wait a second, you're telling me that my case is going to get stayed in the district court? What am I going to do for the rest of my life? Wait for the stay to get lifted? No, no, no. So I need the opportunity to defend my client's patent or to go after the bad patent owner in these proceedings no differently than I would if I was involved in litigation in the district court or the ITC. This is just an extension of this enforcement world. It's just an extension. We're going to an administrative agency, but nonetheless, it's just an extension of the enforcement process. And the Patent Office has a decision on their website on this pro hoc vice practice that they adopted, where they prevented the attorney from participating fully the way they wanted to. And I urge you to go up to the PTO website immediately and read this. And there's a lot of good documents from the board, and I'm sure that Judge Tierney will tell you all about this in great detail later. But the important thing is to go on the PTO website and start reading all this stuff that is being posted. But the important thing to know is it is going to be a team effort, in my opinion, to do this job right for the client. It's not going to just be a patent attorney. It's not just going to be an interference expert. It's not just going to be a re-exam expert or a litigator. It's going to be a team that knows what they're doing because there's a lot of different moving parts. So the question is it going to be faster? Well, arguably it could be faster if the PTO can devise a system and conduct a system that is going to operate within the statutory mandate. And I will tell you that a lot of the district court judges in the patent pilot program off the record are saying, how is this really going to work? Explain to us, who deals with these discovery issues, for example, every day of the week, explain to us how this is really going to work in practice without some kangaroo court type decision making going on. So there's a lot of concern about it being faster. So let's go to better. Is it going to be better? Is it going to be better than the district court or the ITC? Now, maybe it depends on the proceeding. We'll talk about that. Maybe the proceeding matters because if we're dealing with prior art that's patent and printed publication versus everything that can be raised under Section 282 except best mode, maybe it will be better because the Patent Office historically has been able to deal with the issue of patents, patentability relative to issued patents and to printed publications. So maybe it will be better for that type of limited prior art challenge. But will it be better for a challenge involving offer for sale or public use? Remember, this could be anywhere in the world under new 102. Will it be possible in the short time frame that the PTO has under the statute to be able to do the kind of investigation, the kind of decision making that needs to be made to properly assess the right decision and make the right decision for this valuable property right? And many people don't think so. And I would share their concerns. We talk about it a lot in the book, and we'll have to see. But the question is, will it be better? Will it be better because the way they have set up these proceedings is going to severely limit your ability to cross-examine, your ability to tell the story of the invention, the ability to tell the story of the prior technology to this 3-judge panel that will be making the ruling that essentially may be very hard to reverse on appeal to the Federal Circuit, because the Federal Circuit could easily grant substantial deference to the whole process. I don't know. Now let's talk about cheaper. As we know, reexaminations usually had 2 cycles in the central re-exam unit. Then you would go to the board. You may get remanded back. I've had some cases recently where I've been remanded back to the CRU. And then if you win or lose at the board, both sides, particularly an inter-party re-exam, can appeal essentially to the Federal Circuit. So you have 4 steps in the process with the inter-party re-exam world as a practical matter, or maybe more. Now, in this world, you're going to have 1 hearing, 1 trial, and then you go to the Federal Circuit. So it's only going to be 2 steps versus the 4 that you're going to have with the inter-party re-exam. And of course, with ex-party re-exam, if you're the patent owner and you win, you're out of the whole process with the issuance of the re-examination certificate. And if you lose, you're up on appeal through this same process. So it could be 4 versus 2 for ex-party re-exam. So will it be cheaper? Well, these new proceedings could cost $300,000 to $1 million at the board, and could cost $200,000 to $500,000 at the Federal Circuit per patent. And if you have multiple patents, think about it. And if you're the patent owner and there's more than one of these proceedings filed against your patent, which could easily happen, start doing the math. There will be some economy of scale, arguably, but it could be very expensive relative to the comparable validity determination that would be made in the district court case. Now, let's understand a fundamental thought that I tried to get across to Chief Judge Smith and others yesterday, which is the finality issue. In the European system, as we know, in the EPO opposition system, you have 9 months to file an opposition notice. And when the opposition is completed for all the opposers, it's over. You cannot do another opposition again during the life of that patent. Now, you can challenge the validity of a patent in Europe in a regional court when you go to enforce that patent in a specific EU country. For example, in Germany, you go to the Federal German Patent Court. But that's just a challenge. And most of the time, I'm told by the European attorneys who are in the book, in our chapter on this whole subject, most of the time the court, the Federal German Patent Court, defers to the EPO opposition process in a major way. In other words, they only will second guess the validity determination in very special circumstance. Here, with our new system, there is no limit to the number of proceedings that can be filed against that patent. There are none. Now, particular parties may be limited because of estoppels. And so I asked the judge, I said, how is this going to work? How is a patent owner going to get finality like you can get in Europe, for example, as a practical matter, or in other countries where once you get the patent, it was like the old days, you'd go to court and the court would deal with that issue as part of the whole proceeding. So if you carve out the cost of the validity component of your average patent lawsuit and compare it to what you could be looking at now with these contested proceedings, you can easily see many situations, particularly where the patent's being enforced against more than one defendant in one or more suits, where you could have multiple proceedings. And I would submit to you, cheaper is a big, big question mark, because if you compare apples to apples, namely the validity challenge in that district court case versus all these possible contested proceedings, because remember the district
Joining the meeting.
stayed, the cost to the patent owner could be much higher. So faster, cheaper, and better, that was the promise. The jury's out. So let's go through what we have. I want to walk you through the whole world we're now living in. I got to tell you, writing this book was a trip, because I wrote chapter 1 and I wrote chapter 21. Chapter 1 is the overview. I wrote it by myself. I would get up every morning for 12 hours and go, I don't know, what's going to happen? So I tried to guess. So when you read chapter 21, there's no pride of authorship. Send me an email and tell me how wrong I am. But I tried to figure out what we were looking at, and we're in the process of doing version 2 of the book, but the point is, this is our best guess at the moment. The other thing I wanted to say about the book is in chapter 21, as you'll see, we have 13 hypotheticals on what could happen in all these various scenarios that we're all going to be facing. And Chief Judge Smith was quite disturbed by my predictions in that chapter. And I said, Judge, you got to understand, I'm not the smartest person in the room here. And if I can think these things up, trust me, I know people who are going to take these ideas and refine them and develop them and think of things that even I haven't even contemplated. So the idea is when you start to get all the building blocks or all the tools in your toolbox under control, which we're now going to do, and you start using your tools in your toolbox, so to speak, guess what? You're going to discover some amazing things because this thing does not fit together in the way that the drafters like Joe Mittal thought, and I warned him, the law of unintended consequences in legislation, we saw it with the inter-party re-exam, is very real here, and we have just begun to see what the brilliant minds in this room and others are going to cook up. So we have a central re-exam unit still. So what happened? Well, there was, the central re-examination unit was created in 2005. It still exists. It's the examiners that are assigned they're assigned there. It's not a permanent position still because when the AIA was being pushed through, literally, the unions backed away from the management at the PTO, and they were trying to negotiate a permanent position in the CRU, and that never happened. So the CRU is kind of an interim organization.
Joining the meeting.
That office, created in 2005, has over 100 examiners. You can only be you have to be a primary examiner at the PTO. They could not hire me. I was never a primary examiner. They couldn't hire any of you, no matter how much experience you have. You have to be a primary examiner to be in the CRU. Most of the examiners that are in there now, as you probably know, have been at the office for at least 10 years. For a while there, it was considered a very prestigious job, but now there's a lot of pressure on these people and a lot of new members that have been detailed in. So we'll see how the morale goes. And there's a lot of pressure coming from Remy Ussel, who's in charge of that unit. She's the third director that we've had in CRU, and she pushes her team hard. And we'll see how the CRU operates going forward. And the big question mark, of course, is what is the CRU going to look like in a couple of years when the inter-party re-exams have gone away? Because what are they going to be working on? Is it a sort of a sunsetting organization that could be much smaller when we talk about this 5 years from now? Probably. But it still exists. It's been around since 2005. 3 examiners are assigned to each re-exam. It has the ex-party re-exams and the inter-party re-exams and the supplemental proceedings, supplemental examinations, as they're called in the statute, in their jurisdiction. They don't have law degrees, most of these individuals, and the supervisory ranks at the CRU, for those of you who don't know, have been decimated because of 3 factors. Either they've retired, and some have even gone to law school to try to come back to the patent office as judges, or they've gone to the board if they had a law degree, or frankly, some of them have gone back to the examining corps because they've told me off the record it was hell to be in CRU. So CRU supervisors are brand new. Many of the examiners in there are brand new. How many people have a re-examination right now in front of CRU? How many people in here are doing that? Well, as you probably know, it's a little bit of a crapshoot, so to speak, as to how the decision making is going to go, because many of the teams in there are teams that I've never seen before in the re-exams I'm involved in. So you have your CRU, still exists. You have your Office of Patent Legal Administration. The director, Hanlon, Brian Hanlon, is in charge. He used to be a Banner firm. He's an attorney, very experienced guy. He has 20 attorneys working for him in OPLA. One of the jobs of OPLA is to deal with all the petitions that come into the reexamination process. As you know, there's a whole petition practice in reexamination, and that creates a lot of time delays, frankly, in many of the reexams because the petitions have to be ruled on by OPLA in many circumstances. Some of the petitions actually are reviewed by CRU, such as extensions of time. But by and large, the important decisions, the case dispositive decisions, petitions are ruled on by OPLA, and there's no requirement in the statute that OPLA act with special dispatch in the sense that oftentimes we will see a decision from CRU that is overtaken by a later decision from OPLA that kind of moots the decision by CRU. So the disconnect between OPLA and CRU
Joining the meeting.
has been a long-standing problem, and I know there's quite a big backlog of petitions at OPLA that have not been ruled on. And Ken Shore, for many years, was the guru of the petition practice at OPLA. He retired, and now he's back for his second tour of duty at the Patent Office, working part-time. But if you know Ken Shore, there's no such thing as part-time. So essentially, OPLA has Ken Shore back. So OPLA is this organization that deals with the petitions in the re-exam process and the supplemental examination process for the CRU proceeding stage, and they have nothing whatsoever to do with the board. And they wrote the rules on the new fees and everything but the new board rules relating to the contested proceedings. So historically, they've done all the rule writing, but not when it came to our new contested proceedings. That was done by the board. So that's my little overview on OPLA, and we have a chapter in the book on that. So, ex parte re-exam. We've had ex parte re-exam since 1980. The idea was a quality check for patent owners before you went to license or before you went to court. For many of us old-timers in the room, that was what it was created for. It was not created for patents to be bashed. It was created for patents to be enhanced. And that was the rule for many years. And then ex parte re-examination started coming into play in this parallel universe that arose when challengers realized, my gracious, you know, we're not going to get a fair shake on our patent or printed publication defense in front of a jury. We've got to go to the patent office. So ex parte re-exam was continued in the new law. So you might ask why. Well, Joe Mittal told me that there was immense pressure from the patent owner community, particularly the smaller owner community, the universities and the smaller inventors, to keep ex parte re-examination. And the reason for ex parte re-examination was, from the owner's perspective, was that it was a more just and reasonable process for their patentability challenge, because, as you know, once the proceeding is ordered, the third-party requester is out of the process. They're no longer involved. And the patent owner is allowed to interview the examiner team at the CRU, which I would recommend you always do, but be prepared. Don't go in on a fishing expedition. That's fatal. And you're allowed to tell the story of the invention at CRU, which you should and must do. Bring in your inventor and your technical expert for sure. And you're allowed to give the examining group that's assigned to your re-exam, the three patent examiner group from CRU, you're allowed to tell the full story. So the ex parte re-examination process historically has been more favorable to the patent owner than the third-party requester. And it exists after the September 16th date when the new jurisdiction attached to the board for these contested proceedings. So ex parte re-examinations still exist. They're limited to patents and printed publications still, but they could be a very powerful tool for you, particularly if you're dealing with a portfolio where you want to deal with prior art that you have found later, and you want to get that behind you before you go to court, or maybe you are already in court and you want to deal with that. inter-party re-exam. We saw statistically, and we have
Joining the meeting.
the inter-party re-examination process was not embraced quickly when it was passed in 1999. And the reason was the estoppels, the raised or could have raised estoppel that attached to anything relating to patents and printed publication prior art. So the concern of the third-party requester, which is the only party that can file a inter-party re-exam. Remember, ex parte can be filed either by the patent owner or the third party. But in the inter-party re-exam, only the third party can file it, and the third parties, of course, were very concerned about the issue of the estoppel on the types of prior art that could be used in an inter-party re-exam, which is patents and printed publications. So, for example, what happens if during the course of your discovery in the district court, you find the killer reference? What do you do then? So this was a big concern, and many people did not get near inter-party re-exam, and that's when you look at the statistics of filings. For many years, there was practically no activity. And then starting around 2004, things started picking up, and we saw this hockey stick. This hockey stick filing level just goes straight up, because the idea was, as I said earlier, the second bite at the apple is a real live issue, because under the second bite of the apple theory, you essentially can be litigating in the court. If you don't win there as the accused infringer, but you win the inter-party re-exam later, you've won. Because the patent owner has to win in both tribunals, whereas the challenger only has to win in one. So the idea was inter-party re-exam was an insurance policy. I said this to Judge Ilston, and she was offended by it, but that's the case. It was an insurance policy for the accused infringer. And, of course, the beauty of inter-party re-exam is you can raise any number of pieces of prior art and any number of proposed rejections. There are no limits. There's no limits on the size of the request. And we have seen inter-party re-examinations with hundreds of proposed rejections for a single claim. And the patent owner and the CRU has to deal with all of them. And for a while, the CRU started saying, well, this is a representative rejection. We're not going to deal with any of the others. But that's come back to haunt them in certain recent cases where the board has remanded saying you need to deal with all of them. So the inter-party re-examination process turned out to be a nightmare for the patent owner because of the page limits that exist once the proceeding gets started. And yet the unlimited number of references and proposed rejections that could be raised in the intake process. Now, inter-party re-examination is gone as of September 16th. It no longer exists, but there's a huge backlog of legacy inter-party re-exams that the central re-examination unit is going to have to deal with. And we'll talk about that. Supplemental examination. This is this new proceeding that I'm not sure there's been a single supplemental examination actually filed yet. Does anybody know of one? Yes. Now think about this. Okay. So we've got 2 or 3 or 4 versus there has been on average 1 contested proceeding filed every single day since September 16th. There's over 80 now. And the projection at the PTO, according to Smith yesterday, was that by the end of by September 15th of next year, they will have essentially 1 per day under the new contested proceedings in all different technology areas. And I'm sure Judge Tierney will tell us more about that. But anyway, this supplemental examination, what's this all about? Well, it was supposed to be a compromise over the elimination of our famous defense, inequitable conduct. And as many of us know, this inequitable conduct defense is the plague of the patent system. I can tell you that one of the benefits of being a recognized expert in reexamination is that you get charged with inequitable conduct all the time if you're successful for the patent owner in a reexam. It's amazing how many times people have charged me recently. I never got charged with inequitable conduct before I got into this reexam fight around 2005, but every time I seem to win a reexam now, I get charged with inequitable conduct. So much for TheraSense. But supplemental examination was supposed to be this legislative compromise. So what can you do? You can go in as if it's a reexam using any type of what is called a substantial new question. Could be a patent reference. It could be an offer for sale issue. Could be a public use. It could be anything you can think of. You can go into the patent office, lay out the facts, have the patent office decide whether they're going to institute a ex parte reexam, which is what they would do. Only the patent owner, of course, can do this. And if they do this and they don't find any material fraud, then you have inoculated your patent. You've basically cured your patent of an inequitable conduct charge in the district court. Now, of course, you have to do this before the inequitable conduct charge is raised. So the idea was this is a way to not eliminate inequitable conduct, but to give the patent owner a mechanism to inoculate their patent from inequitable conduct. So why is it not being used? Sounds pretty darn powerful to me. I mean, it's arguably an ex parte reexam for the patent owner on steroids in the sense that you can raise any defense except for best mode under Section 282, as compared to the very significant and severely enforced limitation in ex parte reexam of patents in printed publication. Well, I would say to you that you can be charged for committing inequitable conduct doing a supplemental examination. Think about it. All the representations that you make in your supplemental examination are additional bases to charge somebody with inequitable conduct. So while you may have inoculated your patent for an equitable conduct charge for the original prosecution, you're still going to have to contend with what is done in the supplemental examination process. That's one concern. And the other concern is no one knows how the patent office is going to deal with this process, so nobody wants to make the first move. And another issue is if material fraud is found to have occurred in the prosecution, original prosecution, then that matter is referred to the Justice Department for criminal issues. That's pretty scary. So if your client buys a patent portfolio and you want to throw the prior prosecution team under the bus, I'm not. Okay, so we need to watch whether this proceeding will actually get legs. Is this another example of inter-party re-exam where it's going to take a while for people to get their courage up to use it? I don't know. I would predict that the first supplemental examinations probably will occur where a party has acquired a portfolio, they're trying to scrub it for various reasons, and they're going to do supplemental examination to do it that way. But it raises some very interesting issues, and if supplemental examination is being done on a portfolio that you were involved with as a patent attorney, it's going to raise some interesting issues for you to be asking, which is who's going to protect you, the patent attorney, from what you did in the original prosecution? Because remember, you have no standing in that supplemental examination process to defend yourself. Now, I know there are many people in this room who are not worried about their registration numbers, but I am. Yeah. So the question was, is supplemental examination the gift child to the litigator because that's the one it protects? And I don't know. I think this whole inequitable conduct issue has not been solved by TheraSense, which we'll talk about later. But I just, you know, this is going to be the bulk of what the Central Reexamination Unit is going to do once they get past the legacy inter-party reexams. because the only other thing they're going to have are standard ex parte re-exams. And that's why a lot of people at the Patent Office are moving away from being in the central re-examination unit because they're not at all convinced that supplemental examination is going to be used at all as a practical matter. But it was a way for Congress to dodge the elimination of inequitable conduct defense from the law. So let's go back to the Patent Trial and Appeal Board. This is our new board, our new court at the Patent Office. Now, we now know that we have these regional patent offices, one in Silicon Valley, one in Denver, one in Dallas, one in Detroit. And I can tell you that Chief Judge Smith announced yesterday that Neil Smith is the first judge, for example, on the Patent Trial and Appeal Board in the Silicon Valley office, and they're having judges in these various offices. The assignment of these new proceedings will be done around the country, not necessarily where the patent owner is located or where the attorneys are located. So that's going to be an interesting development. And so the new Patent Trial and Appeal Board is not going to just be in Washington, because now that we have these satellite offices, they're going to each of these offices is going to have a Patent Trial and Appeal Board too. The other thing to know, which I find amazing, is that these judges do not have to work at the Patent Office. They can work from home, which is an interesting and I find somewhat outrageous situation. Imagine if you went to the Eastern District of Timbuktu and you found out your judge was living in Uzbekistan. So we have judges on the board who are living in Hawaii. And when you start looking at these timelines that we have to deal with, it's going to be very interesting to see how we're going to deal with judges who are several time zones removed from where you are. So understand we got 3 time zones in the central United States, and it's going to be interesting to see how the judge assigned to one of these contested proceedings is going to decide what time zone they're going to be operating on. But we have this new Patent Trial and Appeal Board, 3 ALJs, or excuse me, APJs, administrative patent judges, per trial. Chief Judge Smith says they're up to about 160 judges. They're moving towards 220. Compare this to the number of district court judges in the entire federal system, which is in the 500 range. And we're going to have over 200 judges at the PTO by next year. Substantial ramp up. We're going to hear from our judge that they're very competent people, and I have no doubt about that. I know a lot of them, actually, the new ones that have been recruited in. They've had many, many applicants. Some of you may have even applied. Many applicants. They've got 12 judges in the training pipeline, and they're still out on the recruiting trail, by the way. And they're paying a lot of money. The district court judges are kind of disturbed about how much money is being thrown at the Patent Office judiciary versus the district court judiciary, where they can't get a dime for anything. So the Patent Office is much better funded, and that could be a very important factor on the stay decision stuff. Don't lose sight of that. So we have this new Patent Trial and Appeal Board. They have enough appeals from ex parte re-exams for each judge to have 2.5 to 3 years of work, just to deal with the backlogged 27,000 appeals from ex parte prosecution. And then layer on the fact that we're getting 1 proceeding per day, so they're going to have 300 plus proceedings after the first year, and they have to do them all within 12 months. It's going to be really interesting to see how they pull this off. But I'm all fascinated by this because, for obvious reasons. And you know, you need to immediately read the rules of practice that they've created. Please, even if you're not doing any of this work directly, read those rules of practice, get a feel for how the process works, the very, very strict timelines that you have to operate under. Very strict timelines. And don't be fooled. No extensions of time. So you're going to need a team of people on these proceedings. Don't fool yourself and think you can do them all by yourself, because they will not take any excuses on missing these deadlines. This is more strict than practically any court you've ever been in. So, but I'm not going to spend a lot of time on this because you're going to get the official version later. and if I sound a little facetious, it's only because I am. I'm facetious for the simple reason that I don't think that a lot of this has been figured out. And how could it be? This is such a big change. No person, no group could figure this all out yet. I think they've done a great job so far trying to deal with this statute, but I think there's going to be a lot of changes that are going to have to be made as we get through it. So, post-grant review. Post-grant review only applies for patents that come out of the first inventor to file system, which, as we know from Keith, comes into force on March 16th, 2013, next year. So nobody needs to worry about a post-grant review yet. Why? Because nothing's eligible for post-grant review. Post-grant review applies for the first 9 months after the patent issues for a first inventor to file patent. Only 9 months. And if you don't get your filing in the first 9 months, you're done. So what do you do? What kind of defenses can you raise under post-grant review? Anything under Section 282 except best mode. And by the way, not complying with the best mode requirement based on the conference yesterday could put you up for grabs in terms of your duty of candor to the patent office. Sort of like it was analogized to being a defense attorney in a murder case. Don't ask the defendant if she did it. Because once you know, you know. So you may have a little conversation about best mode that goes like this, according to the lecturer yesterday. You know, there's this best mode requirement in the law. So if you were to not disclose the optimal composition of your product, it would not affect the enforceability of your patent. But if you were to tell me about that, I would have to disclose it. Have you told me the best way of making your product? This was the hypothetical given to all us practitioners. In other words, is this the patent equivalent of the famous movie Anatomy of a Murder, where the defense lawyer kept saying, you know, this is how the system works. Now tell me, what happened? Okay, so under post-grant review, every defense except best mode under Section 282 can be the basis. So you could have, and we're under the new 102. So think about this. You could have an offer for sale in any country in the world as the basis for your post-grant review. Think of the discovery issues. Think of the proof issues. Think of how the patent office is going to have to deal with that. But that's the challenge and that's the opportunity. Now, the proceeding has to be filed within the first 9 months, which raises the very important question of whether we're going to now start monitoring the patents of competitors. Are we going to start monitoring the patents of competitors knowing that we have only a 9-month window? Are we going to monitor stuff that's published and say, whoops, we can't let this thing go out there, and if it does issue as a patent, we're going to need to challenge it with a PGR. That's the contemplation. Now that, for some industries, may be the norm. May be the norm that you're monitoring published patent applications of your competitors. But for electronics, for example, I don't know many people or many organizations that do. And of course, the big issue, of course, is willful infringement. And even though the willful infringement laws have been significantly changed recently in the last 10 years, and it's much harder to prove willful infringement, if you have a monitoring service and you're carefully looking at every claim, I don't know how you insulate yourself from a willful infringement issue if you don't file a PGR. So are you in a catch-22? Do you either file the PGR or do you have to get an opinion? And why did you get an opinion and not file the PGR? Or do you just ignore that particular patent for financial reasons and say we'll deal with it later? I don't know. Big issue in Washington, the estoppel. Raised or reasonably could have raised. Reasonably could have raised compared to the inter-party re-exam estoppel of could have raised. Now, I'm sure all of you patent lawyers here who are claim construction aficionados can tell us the difference between could have raised and reasonably could have raised. What is the plain meaning of reasonably in this context? I don't know. So the big issue is anybody going to use PGR? I mean, you got to do all this in the first 9 months, remember? So there is a move afoot to say there was a drafting error that should be corrected with a technical amendment to change the estoppel to just what was raised, because it was a drafting error. Shouldn't have been reasonably could have raised. We can spend 20 minutes on whether or not that's true. The opponents to this say, wait a second. If you don't have this kind of estoppel, and Chief Judge Rader has said this in print, then you're going to have gamesmanship played to the max, because people are going to hold back their defenses from their PGR and basically use them later, and the patent owner is going to be harassed into the ground, so that you need a broad estoppel that's commensurate with the grounds that can be raised in the proceeding, potentially. Inter-party review. We've seen a whole bunch of inter-party reviews filed. I think there's about 75 to 80 right now. They're in all different technology spaces. This came into existence on September 16th. It is a sea change, if you will, because it's got this new one-year period, unlike the inter-party re-exam that it replaced. It's limited to patents and printed publications. We've got this trial before the board on this, much different from the CRU, where in inter-party re-exam there was no substantive communications permitted on either side with the CRU ever on anything. Here, you're going to have the full trial. So it's dramatically different. The difference, though, between IPR, inter-party review, and inter-party re-exam is inter-party review is a model that is set up to funnel down the issues to a few, like you would have in the district court. You'd raise a lot of defenses initially, but by the time you got to the trial, you would have it down to one or two defenses. Same in this proceeding, whereas in inter-party re-exam, it is everything that's put on the table. So we'll see how that works. Obviously, they have to funnel it down because they have so little time to deal with it. So many have been filed across broad spectrum of technologies, many different types of parties bringing these. It's rock and roll already in the inter-party review world. This is alive and well. Section 18 proceedings, probably one of the most dramatic examples of how lobbying money can get you anything. This was Wall Street at its best, or it's at worst, depending on which side you're on. Basically, we have created a group of patents that are being discriminated against if you're a patent owner, and being put under necessary additional scrutiny if you're a third-party challenger and they relate to business methods. That group of patents that receive so much ridicule from many quarters. The definition of what patents are implicated by this new proceeding is not yet certain, whether it's financial methods or broader, and we'll be very interested to see how that works. What's interesting about CBM is a lot of things. First of all, you have to be in litigation to bring one, or you have to be threatened with suit. Is that the same as DJ jurisdiction or not? We don't know. Probably is. So you have to either be sued or threatened with suit to bring this. It can only be brought by the third party. It can involve any defense under Section 282 except best mode. Anything. Offer for sale, public use, 112 issues, enablement. It can raise statutory subject matter. This could be the proceeding that gets a lot of statutory subject matter cases to the Federal Circuit in the software area, the method of doing business area. This could implicate personalized medicine if it involves claims that deal with the payment for the personalized medicine. So it's not just limited to financial services, as traditionally thought. So it's a very interesting proceeding. There have been a bunch filed. You can file more than one against a single patent with different defenses because there are limits on the page number for a filing. The fees are high to file these, but when you look at the cost of the overall proceeding. They're in the chain, they're in the noise, so to speak. It's chump change. But the point is, the estoppel is limited to what is actually raised. So you could raise statutory subject matter in a CVM and reserve all your other defenses for your district court. The issue that Judge Rader brought up about post-grant review. The estoppel is much different than post-grant review and inter-party review, which currently is raised or reasonably could have raised, or inter-party re-exam, which is could have raised. Derivation proceedings replace interferences. The difference is you have to steal it, so the person who stole it has the evidence that they stole it, whereas in interferences, you had to show you were the first inventor. So there's been a lot of concern raised about how you're going to actually prove this. This will be done in front of the Patent Trial and Appeal Board. Question as to how this is really going to work in practice and whether there will be many of these derivation proceedings done. We'll see. The trial, as we said, has been set forth in the practice manual, and we haven't had a trial yet, so this is the big year for this. Remember, there's about a 6-month period at the beginning of these processes before they institute the trial typically, and then the trial has to be done within 12 months. So over the next, if you count out 18 months from September 16th of this year, this is the big test bed period that we're all going to need to be watching to see how the trial is actually done, how the whole proceeding is actually done. And I'm sure Judge Tierney, who is the major architect in that process rulemaking, will explain how he thinks it has to be done in order to meet the deadlines. Multiple proceedings, one of my favorite topics, big time in the in the book. Walk with me, please. You're a patent owner. You sue 50 companies. Now, you used to sue them all in one court, remember, in the Eastern District of Texas. And poor defendants, they couldn't defend themselves worth a darn. So that got changed. So now you got to have separate lawsuits maybe, right? That got put in the AIA at the end. So now we have 50 lawsuits. So all these lawsuits are brought together under the multi-district litigation rules, and one judge has them all, at least for discovery maybe not for the trials. Meanwhile, all of these defendants get together and say, we need to talk. We need to have a joint defense group like we did in the old days when we were all in one case. Okay, Rob, which proceeding are you going to file? Keith, which proceeding are you going to file? And we go around the room. Well, we might be filing a proceeding. We may not. We're not going to tell you. We've all been there. Okay, so now we have one or more proceedings filed. Different types of proceedings. Remember, I just walked you through all these proceedings. Think about whether we have a patent involving that has some claims that have some financial methods of doing business claims, but some of them are hardware claims, some of them are process claims that have nothing to do. It could be internalized medicine, personalized medicine claims that also have financial claims to them as well. So that patent is put in a covered business method, 3 inter-party re-exams, a couple, maybe an ex-party re-exam on behalf of the patent owner. Maybe in a couple of years it'll be put in a PGR too, right? So what is the Patent Office to do? How are they going to deal with this? I asked this of Chief Judge Smith. He said, we're going to deal with it on a case-by-case basis. I said, cool. I knew that. But how are you going to do it? That's when he jumped on me. Is this my deposition, Rob? But that's what we all want to know. Are they going to stay some of the proceedings? Can they stay some of the proceedings? The law gives them a lot of discretion on what they can do. I talked about this with Joe Mattal big time. Are they going to give any deference to the first proceeding over the second, third, fourth, fifth, sixth, seventh, eighth proceeding? What's going to prevent a patent from being hit with proceeding after proceeding after proceeding every time a wave of lawsuits is filed? You paid your fee. You've got your basis. The estoppel doesn't apply to you. It applies to the party that did the last proceeding. You can do it. You're being sued. Why shouldn't you get your day at the patent office? I don't know. Maybe you should. So this law does not deal with this problem. Unlike the European system, which said you got 9 months to do your opposition, you're done. So we've got a multiple proceeding window that exists for the entire life of the patent, and maybe even after the patent has expired if you're looking at past damages. Estoppels. We talked about the... Yes, sir. Well, the question is about joint defense groups, which is always the question. How much involvement can you have in a joint defense group and not be implicated by the estoppel of the party that brought this proceeding as a member of the joint defense group? How far can you go? And no one knows. And the Patent Office doesn't really have a dog in that fight, to be honest, because the estoppels attach to the district court case. And the district court judges have told me, wait a second, shouldn't the Patent Office figure out who's implicated by these estoppels in their proceedings? So I know. And the Patent Office said, we're not dealing with that. And I'm in a case right now where we're dealing with this issue, one of the new first IPRs filed, because I'm convinced that they've already stepped over the line. It's my view. And so am I going to be engaged in litigation tactics at the board by raising this issue on behalf of the patent owner? And so the district courts have discovery that they could do, but they can only do that once that first set of proceedings is concluded, because that's when the estoppels attach. When the final decision of the board is handed down, that's when the estoppels attach in these new proceedings, whereas in the inter-party re-exam world, the case law says that the estoppel attaches only when all the appeals have been exhausted. So think about this for a minute. You could have estoppels attaching that says that you can't use that art in a district court case while the proceeding is going on appeal to the Federal Circuit, because you've lost the IPR as the challenger. Meanwhile, in the district court, you're stopped from using this art. And then the Federal Circuit reverses the Patent Office, but your trial's over, right? And you were not allowed to use that defense in your trial. So what happens now when the district court case makes it to the Federal Circuit? Who knows? So the estoppels get very interesting because you've got no estoppel for ex parte re-exam. You've got raised or could have raised for inter-party re-exam, bidirectional between the court and the Patent Office and the Patent Office and the court. But for the other estoppels, it's only from the Patent Office to the court, not from the court to the Patent Office. And most people don't realize this. So you can raise the same defense in the court that you can raise in your proceeding in your district court case. So it's very complicated. And then you've got this issue of certain proceedings, such as CBM, are limited just to what was raised, and other proceedings are raised or reasonably could have raised. And with post-grant review, let's say there's an offer for sale defense that comes up later in discovery that you never knew about. Are you precluded from raising that because you filed a PGR? So it is really, really complicated. And then you throw in the joint defense group issue, multiple proceedings, and it gets exquisite. Third-party submissions, a process for getting prior art into the Patent Office, very inexpensive. Question is it a poor person's re-exam? Will people use it? Will they not use it because it will eliminate the ability to attack the issued patent because this art was considered and is no longer available for one of these new contested proceedings? Who knows? Fair number have been filed. We'll see how it works. Of course, you got to be monitoring the patent. As many of us know, There are strong reasons, if you're the patent owner side, to have a open case still around that you can be prosecuting while you're dealing with these contested proceedings and while you're enforcing your patent portfolio. And that's the prosecution overlap that we talk about in the book, about the importance of prosecution. Prosecution has become more important, I would submit to you, now under this new regime than it was in the old days, because you may be able to do things with reissue or with continuation applications or whatever that you could not have done in the re-exam world because you didn't really need to worry about it. So be the patent prosecutors in this room, you need to know this new world, at least from the perspective of how it's going to impact on what you're going to be allowed to do in your prosecution of families. Yep. Yeah, and the point to the people out there in the for the webinar is that for startups and other companies, they need to budget for this new prosecution burden. I need to go through a bunch more points, and I'm going to move a little quickly here, but I wanted at the beginning to give you a firm framework of the tools in your toolbox. Now let's start playing with them. So we have this interface between the district court and these new proceedings. Remember, the district court does not have to stay their proceeding, except there's a heavy presumption in the covered business method that the court should stay. And matter of fact, Wall Street went one step further and put in a mandatory
Joining the meeting
of the stay decision in a covered business method proceeding. Regardless of how the court came out, they have a mandatory appeal that has to go to the Federal Circuit on that stay decision. And of course, the Federal Circuit's going, what? We've got to deal with a stay decision in every case having a CBM? And the answer is yes. So, first point to remember, the judge does not have to automatically stay just because one of these proceedings is ongoing. And I would submit to you that a lot of courts will not stay. PTO ITC proceedings interface. As we know, under Section 337, the mandate for this Article 1 tribunal is to discharge its responsibility in a very prompt manner. And in talking to some of the ITC judges at other conferences about this, I've been led to believe that they're probably going to continue not to stay their proceedings pending the completion of these contested proceedings, except maybe in a very exceptional circumstance where the contested proceeding was filed before the ITC proceeding. So I think as a practical matter, you need to assume that there will not be a stay of the ITC proceeding, particularly if the contested proceeding is done as the ITC case unfolds. And then we've got this huge increase in work between the Patent Office world and the Federal Circuit. We've got these mandatory interlocutory appeals in covered business methods. We have 27,000 backlogged ex parte appeals, 3% on average. 3% on average get appealed to the Federal Circuit. If Judge Smith is correct that they're going to whittle down that backlog, say by 20,000 cases, right? That's 600 appeals to the Federal Circuit in the next 3 years or less. Throw that on top of the 100 of some appeals from the from the PTO now to the Federal Circuit, add the legacy inter-party re-exam appeals and the ex-party appeals and the new contested proceedings, and you're going to see 400, 500, 600, 700 appeals from the PTO involving these contested proceedings or from the district court, and Rader and others are going, whoa, how are we going to do this? And they can't even get new staff attorneys, according to interviews from Rader, because there's not enough money, and yet the Patent Office can hire scores and scores of judges. So there's a lot of friction there. There may be challenges under the Administrative Procedure Act for a lot of what's going to happen. Who knows? We'll watch. It's possible. I think it will happen. Section 146 actions and Section 145 actions to the district court to get new evidence in, very limited now. As we know, you've got derivation proceedings where you can go to the district court, but for ex parte re-exam, you can no longer go to the district court to get more evidence in. So that, the Hyatt case was kind of nipped in the bud relative to re-exams. Strategy and hypotheticals. Once I had gotten this book edited and I had written Chapter 1 and gone over Chapter 1 a couple of times, I decided before I forgot everything, I had to write down my nightmares, and that's what this is all about in the book, Chapter 21. All kinds of scenarios that we've been covering today are in there. I urge you to take a look at that. And then, of course, we have to put this all in the context of this patent or patent family as it's being enforced around the world, whether it be in Europe, Japan, China, Taiwan, South Korea, you name it. We've started to deal with that issue in the book, and we're going to expand that for the next edition. So let me give you 6 predictions, and you can see these predictions on YouTube. I've got each one of these predictions on YouTube. Just put my name in on YouTube, and you can see them, but let's go through them. First of all, the spike. The spike occurred right before September 16th of this year, when as many ex-party re-exams and as many inter-party re-exams were filed in the last 30 days as were filed in the preceding 11 months. So CRU saw its workload double in the last 30 days. How are they going to deal with this? Particularly since, by statute, they have to order these re-exams within 3 months because they have special dispatch for inter-party re-exams. So we're seeing stuff flying through the office, at least at the initial stage of the re-exam process, as the CRU tries to deal with this bulge, this spike in filings that occurred. Why did this spike occur? Well, for inter-party re-exams, guess what? Since you couldn't file an inter-party review if you had been sued for more than a year, some people were forced to file an inter-party re-exam because they had no choice, because they couldn't file an inter-party review because their lawsuit had been pending too long. Second of all, the fees went up substantially. And third, with inter-party review, as I said earlier, there was no limit on the number of references, patents, or printed publications you could raise, or the number of proposed rejections. So a lot of people said, this is a much better process for an accused infringer than the inter-party review, which we don't know how it's going to work. It might be more balanced for the patent owner. So we're going with inter-party re-exam. For ex-party re-exam, the fees went up significantly. Next. How do we get it all done? Well, we've been talking about this, or I've been talking about this a lot already, which is how is this all going to get done? We know one thing, don't expect extensions of time. So get your team ahead of the curve and stay there. How is the board going to get it all done? I'm not sure. Next, obviousness is king. As I said earlier, there is a huge asymmetry between your ability to show non-obviousness in the district court, where you can tell the story of the invention, you have the clear and convincing evidence standard, the substantial evidence on review standard with the jury verdict, versus the PTO with the different claim construction, the much lower burden, and the fact that the PTO cannot really deal with evidence of non-obviousness. They have this huge nexus requirement, and frankly, it's very hard to show that nexus. And it's very hard to provide the kind of testimony that you would get from the inventor and the technical expert that you would get in the district court case, because there's no live testimony in the trial. It's only through deposition testimony. That's how you get your evidence in these new trial, is through depositions, not through live testimony. So I would submit to you, obviousness is the biggest problem for patent owners now in this new world. It is the biggest problem. Get in front of it. Inequitable conduct defense is alive and very well. As I said earlier, welcome to the new world. If you're doing these proceedings for the patent owner, you are at risk. Your team is at risk for an accusation of inequitable conduct. Whether it sticks or not, who cares? TheraSense is not this big development that everybody thought it was for this issue, because TheraSense still says that affirmative statements that you make can be the basis for an inequitable conduct charge. So TheraSense doesn't insulate you from any of the stuff that you're doing in this kind of world. It's only for stuff like art that you didn't submit. So be very careful. To stay or not to stay, that is the question. That's the question for the district court. That's the question for the ITC. The Patent Office is not going to stay their proceedings because they have a statutory mandate of 12 months. So it's going to be very interesting to see if the district courts create the serial world or whether we live in our parallel world. And last but not least, and this goes to the comment from our audience, the games that will be played in the joint defense groups. I call it estoppel peekaboo, which is everybody gets together, decides who's going to do what, when, and how, and they all play this game where they can continue to raise these defenses individually in a court case, but those defenses in the court case help everyone in that court case, because once the patent goes down, it goes down against all the other accused infringers. So I call that estoppel peekaboo, and that is all I've got to say. Questions? Comments? Keith, 5 minutes to go. How was that? Yes. Could we? Right. So the question is, if you have a patent that is under the old regime, first to invent, and it's a CIP is filed on or after March 16th of next year, adding claims, will those new claims, which now convert that case to a first inventor to file case, would that subject all the claims to a post-grant review risk? Specifically, would the claims that were filed in the original application that are now in this new application be subject to post-grant review? And I don't know the answer to that. Yeah, or even in a supplemental. Well, you could file a supplemental examination now if you're the patent owner. But it would be the big issue would be the post-grant review. And I don't know the answer to that. Maybe Judge Tierney does. I don't know what they're going to do. I'm not sure they've really gotten their hands around what they're going to do with that yet. My guess is that if the patent is under the first inventor to file regime, even though it's the older claims, I would think that post-grant review arguably would be available. But I don't know. Next question. That was a really good question. Thank you. Yes, sir. Well, this little colloquy that was presented in Palo Alto yesterday, the issue of, best mode and what you, as a patent attorney, what do you do to protect yourself if the inventor doesn't tell you the best mode deliberately? Question was raised, do you have to tell the inventor while you're going through your little drill that, by the way, if you don't tell me the best mode and we don't put it in the patent application and we don't get a narrow claim on it, you don't have a narrow claim on it. Therefore, you may lose that way because the broader claim goes down, even though it doesn't go down for best mode. It goes down for validity. Do you need to do that to insulate yourself from malpractice versus your obligation to the PTO under your duty of candor obligation under 1118 rule? And how is OED going to deal with this little game? I don't know. The presentation that brought this up actually dealt with malpractice under the new AIA, and how are you going to deal with the best mode requirement under the AIA? Particularly if you tell the client, look, best mode is gone. We don't have to disclose the best mode. And after you've had that long dialogue, the inventor says, you know, the more I think about it, I don't want you to put that range, that set of ranges in the case. I just don't want them in there. It took me years to figure this out, and I'll be darned if I want anybody to know this now that we're going to market. I don't know what to do. Feels like you're in a murder one case, right? I don't know. I don't know the answer to that. I'm sure that if you were to go ask OED how to do it, they would immediately institute an investigation against you. So do not ask OED what to do. You laugh. A friend of mine had a question like this. He hadn't done anything wrong. And they brought an investigation against him by just asking the question. It's not like a bar association counsel where you can go and say, hypothetically, doesn't work that way with OED. So be careful with OED on this. I don't know what they're going to do. Next question. Comment. Well, thank you again for the opportunity, and welcome to our new world. As you can see, it's simple, well-defined, and we'll all have fun. Thank you very much.
Joining the meeting.
Thank you, Rob, for that great presentation. We're going to take a 15-minute break here in Seattle, and on the phone we'll reconvene as well in 15 minutes with Ron Kastenelson beginning his presentation on the first submitter to file and the diminished grace period and prior art issues. Ron, I think I heard you join on the phone. Just before I move on, one point of note on we just have the slide up now on where you can order your copy of Rob's book. Ron, if you're on the phone, can you unmute your phone and say something so I know we can hear you? All right, Ron, we weren't able to hear you yet. We'll try to get in touch with you another way and get you on the call for 10:45. So, folks on the phone, we're going to break here and reconvene at 10:45. Thank you.
Yeah, that's a really good point. So why do people, some didn't figure it out as far as motions and larger, not the group. Right. Almost 10%. In PDF, it's 30%. they want to show to the court that Let me hit the bathroom. Thank you.
Hey, Ron, can you try to say something again?
Joining the meeting.
Ron Katz-Nelson. Hello?
Ron, was that you who just joined?
Yeah, I did. Do you hear me?
Okay, great. We can hear you now, so you're good to go. So we'll
It asked me for
reconvene
client
at 10:45, and
asked
we can
me-
hear you in the room just fine.
It asked me for client matter and some other number. I didn't have it. I just entered blank, so, but it did work. So let me set up my slides.
Joining the meeting.
Don Janeway.
Folks in Seattle, request you to take your seats. I know you're enjoying your networking and the break, but it's time to get started on the CLE program again. Folks, we're going to get started again. Can you please take your seats? So let me introduce you to Ron Castleson. Ron has graciously agreed to talk to us about the act from the perspective of a business owner.
Joining the meeting.
James Jantusek.
Ron, I'll let you get started, and then and we'll cover some more information a little bit later. So why don't you get started on the CLE program?
Thank you, Rajiv. I'm trying to see if everybody can hear me over there. So, am I well understood and heard?
We can hear you just fine over here, Ron, in Seattle, and the folks on the phone should be able to hear you just fine as well.
Thank you. I'm Ron Katz-Nelson, and I appreciate the invitation to speak to you guys. Unfortunately, I was not able to come there physically, so I'm doing it through a remote site. My experience has been prior to the passage of the AIA in efforts to prevent some sections of it. We didn't succeed, mostly from the small business and startup side. Now that it exists, we are working on trying to work through the AIA and see what it means to startups, particularly startups. So the focus of my talk would be on issues related to the startup community, and particularly on first to file, redefinition of prior art, the implication to the very constraint and essentially effectively eliminated grace period, a little bit about some prior user right and what they mean and how they interact with other patenting opportunities. I'm probably not going to speak about the filing a non-inventor's oath and declaration and post-grant review. Rob spoke about post-grant review and supplemental examination issues, but those may be mentioned in passing. Finally, I will talk about some of the new fee proposed under the fee setting authority for the Patent Office and the new entities, new micro entities, 75% discount compared to a large entity.
Ron, this is Chris Lack. Ron, I've got a traveling mic, and for anybody in the audience, if you've got a question and you raise your hand, I'll try to accommodate any questions during Ron's presentation. I'll give you a little bit of forewarning. Will that work with you?
Sure, it could be, and I do have a couple of stopping places and topical places to stop for questions, as it's organized probably in 3 different groups. But sure, any time there's a question on something stated or said or shown, I'll be happy to get interrupted.
All right, thank you.
Talk about the current practice of what we do today and how it might change, will have to change under the AIA. And clearly there are some substantial reconsiderations that are now before small businesses and startups in terms of the opportunities potentially to maintain secrecy under the trade secret protection. And that trade-off has to be revisited again with different parameters to consider. And also I'll talk about defensive and offensive practices that small entities and people ought to look for. Some of which,
Joining the meeting.
Jamie Serene. Spoken of. The first issue is the first to file, also called first inventor to file, but it's really the question of redefinition of prior art. We will have for 20 years 2 systems, 2 concurrent patent systems, both in prosecution and in litigation. There will be 2 sets of rules to govern those, and that could not be underestimated in terms of complexity, in terms of confusion, in terms of how to deal with 2 classes of patents and 2 classes of proceedings. That is a real big difference. If you encountered trying to educate inventors and startups with the rules, imagine this would be twice or perhaps even 2.5 times as complicated. Confusion will probably lead to various trips and errors, and a lot of vigilance is required. The AIA Section 3 is the one that talks about the first inventor to file, and that's the amendment of Section 102 and 103 and invention date system. The first to file per se is not a real issue because it's not a question of contest like interferences. There are only about 20 or 30 interferences per year out of 500,000 applications filed. And so this is really a red herring. What really matters is prior art, because if first to file from the point of view of a contest of two inventors or multiple inventors claiming the same invention at the same time, roughly the same time, it would have been easy just to amend Section 102G. Well, that wasn't done. So this whole thing is not about first to file. It's really about redefinition of prior art. It therefore eliminates virtually, and you'll see why it should be treated as having essentially been eliminated, the one-year grace period that protects non-public inventors' fundraising, marketing, R&D activities prior to filing. Note that I'm not talking about publication because many startups, unlike universities, perhaps do not use the concept of publish or perish. It really is the opposite. It's publish, then perish. In other words, we are in a mode in which publication is not really something that we're considering. However, things related to activities that help us build businesses, raise funds, start finding strategic partners, sharing information with outside vendors, trying to get contracts or subcontracts to build our stuff, that kind of activity is currently protected under the grace period of 1 year, and it's obviously going to be effectively not available under the AIA starting March 2013. It does replace interferences with derivation proceedings, not that derivation proceedings were not already in place. There's quite a bit of derivation law because a certain fraction of interferences included derivation proceedings under the old law. So derivation per se, derivation law, isn't really changing. At least there's no indication in the AIA that criteria for derivations, criteria for finding derivation have actually been different. The rules in the Patent Office have changed, and we have commented on those issues. They're trying to avoid the concept of account, for example, and there's going to be some real questions how, in fact, common subject matter will be defined in order to find that a derivation proceeding is appropriate or is covering the right subject matter. Section 102 is really the core of the redefinition of prior art and first to file. As you can see, the current law under Section 102 essentially says public use or on sale in this country more than 1 year prior to the date of application for the patent in the United States. That's the essential element of the grace period. The AIA provide no such grace. It also introduces new contents, new terms. The grace that is provided, oh, and by the way, you can see the other difference is the fact that certain aspects in the preamble not really meaning much, but it's an indicator that the loss of right to a patent is no longer a term used in 102A today in the AIA. And those are the bars associated with public use and on sale and things that have very little to do with prior art, especially if you're talking about secret commercialization. There's no concept of prior art in secret commercialization. It's just a matter of a forfeiture of a patent right, as we'll speak to in a few minutes. There is an exception for the limited grace period, but it has to do with a disclosure that is made 1 year or less before the effective filing date, and a disclosure made by the inventor or joint inventor or by somebody who derived it from the inventor. But in any event, grace is provided only for publicly disclosed material, and there's been clear legislative history that that disclosure needs to be an enabling disclosure for this to actually catch on and provide that type of grace. There have been those who have argued that there's a symmetry between the 102A and 102B exceptions in terms of what is subject to the grace period, but that symmetry is only essentially provided in the legislative history and colloquies. I couldn't see it, and one could not really read it in the statute. That symmetry does not exist in the statute. Therefore, we are very skeptical as to whether, in fact, effective grace is provided for on sale and public use applications. And if a publication is made, it has to be essentially fully disclosing and fully enabling. If you're disclosing a genus and somebody later discloses species, based on the rules that PTO is now putting forth on first to file, and based on actual reading of the statute, you probably do not have protection under the grace period. And so that is an important point. The result is confusion. For some reason, the title here disappeared, and the title says the grace period or the has a lot of uncertainty. The terms public use and on sale have well-established legal meaning over 600 years, 600 cases for 170 years. There are new terms otherwise available to the public or subject matter of the patent we've never heard of. These are terms that have to be interpreted in courts, by the patent office. Tribunals will have years of time to define what that is. Old Section 102A had terms like unknown or used by others. It's no longer in 102 now. What does that mean? Is it the same thing as otherwise available to the public? We don't know. There was a Senate colloquy and other colloquies explaining ambiguities, but some of them never took place on the Senate floor. They were placed in the record the day after passage, on the Senate side, for example. So we're probably not going to be seeing courts that would interpret this legislation necessarily based on that colloquy, and so you really want to stick to see what the language actually says. And as a small startup business owner, I can tell you that I would not assume that I really have any grace period here. And so that's my advice to a lot of people who are looking at this. Do not rely on anything related to the grace period. It's effectively not really there. Now, the confusions that we have here, or the ambiguities, I argue is not necessarily a bug, it's a feature. Having been involved in efforts to influence the language of this act as a small business and an advocate to some of the areas, I found that people on the Hill were very reticent, very reluctant to do anything that would change the language. They, in fact, wanted the language to stay the way it is, fully aware of some of the concerns and the uncertainties. When Congress resorts to organized, pre-planned colloquies on the congressional record.
Joining the meeting.
And when those organized colloquies were essentially known to the staff 6 months or a year before, and were not shared with people, we've asked for those. You can see that this is not a bug. It is a feature. But that's my perspective. The uncertainty is going to have a huge impact in terms of time to resolve these uncertainties. This is a record of Supreme Court decisions only on the matter of public use and on sale bar. Only on these, and there are about 16 of these cases or more, which many of them occurred right after the Patent Act of 1839, 1870, and you can see things got to the federal, to the Supreme Court, and basically it took 2 decades to get some of these things resolved just at the Supreme Court level. Imagine what happened after that in the appellate courts and district courts later on over the years. So we're talking about 600 or so cases since then, over 170 years. But the point is that only that part that clarifies the meaning of public use and on sale could take 2 decades. Now, does the AIA repeal the bars against patenting long-held commercial secrets? As we know, we now have that. It's called under metallizing engineering, that bar. It's not a prior art issue. It's a policy issue. It's, in fact, grounded on Constitution in terms of limited times, limited terms of exclusive rights. The Pennock v. Dialogue decision kind of frames the whole concept as to the motivation for it. If an inventor should be permitted to hold back from the knowledge of the public the secrets of his invention, if he should, for a long period of years, retain the monopoly, it would materially retard the progress of the science and the useful arts and give a premium to those who should be least prompt to communicate their discoveries. That is essentially the Supreme Court view as to why you really have to decide whether you can disclose something and patent it right after you make it commercially and usable, right after it's ready for patenting. And the famous metallizing engineering decision puts it out by Judge Learned Hand in a very succinct way. It's basically the choice that people have is either to patent or exploit that in secret and forever forego patent rights. That is the current law under metallizing engineering. The AIA, when you read it, plain language of it, doesn't say that metallizing engineering is gone. Colloquies and Senate legislative history says otherwise. It says that it has been repealed. So the USPTO, for example, in its new rules, interpreted the AIA as having repealed the secret commercialization bar in metallizing engineering. We at the IEEE USA Patent Committee actually filed comments requesting the Patent Office to take the position of the plain language of the Act rather than using legislative history so as to take the most applicant adverse position, and that is not to grant patents under those conditions. As remember, under 102A, there will be opportunities to bring cases to the office, even on issues related to prior use on sale. And so that would essentially get to the courts quicker by getting this resolved earlier and essentially protecting the public from patents that probably shouldn't issue if indeed the reading of the statute is that there is no repeal of metallizing engineering. The problem if it's interpreted like that is that companies could then evergreen old technologies that they kept as trade secrets for years. Even those that now are trade secrets for which patent rights have been basically forfeited, they can all come back now under the AIA if that interpretation is there. You will all of a sudden see out of the woodwork established companies who use some processes that might be now patentable, even though they've been used for years. So that potentially could be a real minefield. Courts would have to rule on this. It's a substantive regulation. PTO is not entitled to deference, does not have a substantive rulemaking authority on this issue. So its interpretation of the statute in this area doesn't control. we as businesses and inventors cannot assume that PTO is correct. We would not take the chance and go to a trade show with some invention without any disclosure, or go to a potential client or customer, try to sell something, offer for sale secretly, thinking that we're protected and that we have the same system as the Europeans do. And that is, if it's not made public, if it's not really available to everybody in the public, it's just offered for a particular party under non-disclosure and they're using it, it's not safe to assume that. Another risk of the AIA structure is what I call the false patents. This is inherently related to the fact that under 102A, the invention is no longer an issue, and the only thing that can invalidate a patent or can make an application unpatentable is public or published information. Any action of anybody or any party prior to any publication is not a fact element that comes into play in terms of patentability or validity of a patent. So imagine you have an inventor who's first to file, inventor A, is going through a prosecution, but maybe he's doing it under secrecy. Maybe he is elected under 122B to keep his application unpublished, goes through the regular process of 3 years or whatever it takes to get the patent through the office. And by the way, there are about 20% of U.S. originated applications, 15 to 20% of U.S. originated applications that are going through the secret path, election under 122B. About 8% if you include all foreign nationals who file applications in the U.S. But U.S. Sourced is about 15 to 20%. So there's quite a few of those who are basically going to be seen, issue, and going to be published for the first time after issue of the patent. And then imagine inventor B filing after A under these rules, but maybe he's using the expedited examination track, which the patent office, by the way, issues about within 5 months on average. There's over 5,000 prioritized examination applications per year, roughly, and their average pendency is way below the 1 year that the PTO is promising. So they're doing a good job at 5 months. Well, then you have a real situation where a second filer, B, would get a patent. Why? The examiner for case B would not be able to cite a secret application, even if he knows about it. Could not provoke an interference between the two of them. There's no such thing as interference. 102F is no longer here. 102G is no longer here. The only way to invalidate patent B is to find a printed public publication. Well, none exists. PTO may have to issue this patent. When that patent issued, applicant A is going to be having a real serious problem. He could be sued for infringement of patent B. What can he do? Nothing. He can't provoke interference. There's no derivation involved here. There's no proof that B derived it from A. What is he to do? And that could be a serious set of problems and real structure that happened under the AIA. PTO, when asked about this, or when we asked about it in a roundtable, we got an answer. An answer was, well, A has an opportunity then to publish his application, even though it's not issued. You can go and voluntarily publish the application. And then what? PTO is not going to do anything unless the A files a PGR or some form of a post-grant challenge at a high cost. And by the way, at that point, he's going to have this Hobson's choice. You know, maybe he, for a reason, didn't want to publish his application, didn't want to reveal his trade secrets. Maybe he's not sure he's even going to get issued. That makes it a very difficult issue for those who are going through this track. So one thing to look out for, and this increases the vigilance requirement. You know, the expedited examination tracks are going to be something you've got to look through again, either as potential user of it to defend yourself on that, or as a means of looking to see that there's nothing out there coming out of the woodworks in that way. There's a period of time that the false patent will be enforced and, in fact, presumed valid. Presumption of validity, clear and convincing is required. This could be a real serious problem. Are there any questions up to here before I get into prior user rights?
There's nobody in the audience here who has a question.
Okay, I'll move on. The other change in the AIA is the expansion of prior user right. It amended Section 273, provides an expanded defense based on prior commercial use of any process or any machine manufacture or composition used in manufacturing or other commercial processes. I think that's pretty broad. I cannot see that this is not, you know, a majority of utility applications. At any rate, that is now available, and it requires commercial use at least 1 year before the effective filing date of the asserted patent, and applies to any patent issued on or after September 16th, 2011. So this is already in play. In other words, the defense, prior user defense, can be asserted for any patent issued after September last year. So that opens up a whole new area. It also means that as an inventor, you might need to consider whether, in fact, you want to avail yourself of these prior user rights, being able to keep a record of your invention and keep it secret. Now, what does it mean in terms of the process of trying to get protection for your invention? You have a flow diagram of some R&D development in the companies, my company, for example, where we have digital signal processing technologies, RF, and looking at the typical development path, including an invention path. So, you know, today, under current law, we would probably see a full concept design going on. We'll probably try a few alternative system ways to do things. That takes time. We'll select one of them. We'll then build the system design, hardware design, software, and in this case, the gate array or VLSI design, build a prototype. And then now that we have everything there, we know the enablement requirement, we know the details of the application, we'd file a patent application here. We'll disclose a lot of this material as to provide the best claimed support. We might further improve these things and maybe file another application, perhaps a CIP or a continuation with capturing certain claims, or even a new subject matter, a new application derived from some of these other secondary inventions. But you see, this process today enables us to develop things and work with the patent system side by side. The patent system doesn't command our development process. It's basically part of the best practices. We just move forward, and it adapts to our R&D effort. We have abilities to do that today. that may change, and that will have to change under the AIA. The concerns are not here about first to file. It's about the grace period. And so what happens here, the AIA legal change is best described not as first to invent versus first to file. You see, this is the important thing. It's really a difference between first to conceive and first to reduce to practice. That is really the nature of this distinction. It's not really about rushing to the patent office, because you may have nothing to rush to the patent office with. That's our problem. The grace period is designed to allow us to perfect the invention, to vet it, to get the best disclosure, to support the claims, to see what it is that we ultimately really need in terms of claiming. Piecemeal development and small budget would be much riskier, because now it's a reduction to practice that will be required. It's the filing date that is really the point. It's the really reduction to practice date that is now governing the issue. So this is what really is me. Now we're having a situation where the possession of the claimed invention is really our priority date. Okay, we don't have to have every 112 element on that date. Okay, this is important. We have to, perhaps through affidavits or other forms, to show that we have possession of the claimed invention at that time. The requirement under 112 comes later. It comes at the time we're trying to file an application after we've reduced it to practice. We then have the burden of enablement and so on, and the full disclosure, written disclosure, and everything. So the law really changes what we look at. And that is the difference. It's really a first to conceive versus first to reduce to practice. If you have the diligence, you obviously are entitled to the possession of the claimed invention date rather than the date at which you reduce it to practice. Now, you're going to be handicapped by resource limitation. Remember, possession of the concept means nothing in terms of the filing date. Now it's important that your duration from that time until the point you have reduced it to practice, ready to file an application, is as short as possible. And that's exactly the resource limitation small businesses and startups have. And by the way, a lot of people may not have understood why is it that small businesses and inventors have so objected to first to file. This is the reason, the big disparity in resources. So what does it mean? Well, it means now that in every step of the way, we would have to potentially file for an application to solidify a certain filing date. Keith talked a little bit about that, but this is showing, that you would probably have quite a few applications in the process. Not all of them would be really the right ones. For example, here, maybe one application would cover material that is not going to be necessary after you really explore and do the work. This could take a year or 6 months. You may even disclose unnecessary things and as you go through the process, and that would be another issue. Now, how many of you have filed Rule 131 affidavits ever in your lifetime? Maybe, Keith, you can kind of pick up, show of hands there.
Ron, there's about 10 or 11 hands that went up.
Okay. So quite a few of you know, when you have to go through a Rule 131, you have to basically provide a material showing something that is prior to the application, a lot of material that you might have. So here's an example of some affidavit material of Rule 131. Note that that this affidavit has a lot of redacted elements in it. And the reason for that is, well, at the time that claims have to be supported, that redacted material is no longer necessary. Okay? And so a lot of redacted area just is not necessary to support a claim. But you wouldn't know it at the time that you must have filed or needed to file under first to file. So now, are you going to be able to redact an application that you filed in the chain on which you want to rely on? Maybe. I don't think so. There's no provision for that. So there's a lot of issues related to disclosure or gratuitous disclosure that we're going to have to decide how to deal with. The consequences of eliminating the grace period is twofold. One, it fundamentally redefines the prior art and patentability, including prior art that actually may have been created after the invention date to bar a patent. That's significant. It would require this, as I said, R&D planning, very frequent invention reviews, and some distraction, significant distraction of inventors from their work to really force them to go through. Is this your best mode? Is this the only way you can do it? How would people design around it? Can you give me another embodiment? Give me another form, because I'm concerned about lizard tech. You know, I want to have more examples. I want to make sure you have claims that are read not only on the specific embodiment that you have offered here. So that is something that is going to have to be done in every place, in every phase. Is it doable? Yes. Do small businesses and startups have all the resources to do it? Well, a lot less than large companies. Important point to make is that the pilot production for subcontractors is an important point. Because we don't believe that on sale has any grace under the AIA, we certainly wouldn't recommend people to assume it exists. When you have a subcontractor who's, for example, you're a chip company, you're taping out a design, that is a sale. The subcontractor is selling you something at potentially commercial quantities in a pilot production, and that triggers, you better have had filed prior to the tape out, for example, prior to ordering from subcontractors for these pilot productions. Today we have a year from that time, and the pilot production may have some improvements, and we can then capture them in the full disclosure within the year. We can get a better application that way. People will trip. There will be a lot of cases where these things will happen. You probably need to make sure your clients are well advised about these two type of relationships with subcontractors. Now, what importance is this year, grace period for prior art? Very much a lot. This shows the distribution of sources in EPO rejected patent applications based on sources, based on prior art, is comparing it to the filing date of the application. You can see that T equals 0 means that everything within the year. So within the year, and T minus 1 means everything within the year to 2 years. So prior art sources that are cited in applications that have been rejected by the EPO under the first to file, no grace period, are significantly within the first year. As you can see, over 25% of non-patent references and 20% of patent references. Now you might ask, what is this T plus 1? Well, a lot of times later art is submitted to help explain the skill of the art or to explain concepts. So that's kind of what you find in those situations. They're just there. And as you go from older art, a lot fewer of those. So there's a significant fraction of prior art that comes exactly in the period that we now in the U.S. enjoy in the grace period. That doesn't mean that we didn't invent it before that 1 year. Often it does. But nevertheless, don't underestimate the amount of art that almost comes and publishes or is applied for at the same time or roughly earlier or later even than your invention. Now, when do we file an application today after we know we have an invention? This chart shows the cumulative distribution of the delay, the time between the disclosure to a transfer technology office at the universities and the priority application filing. So a tech transfer office at the university gets a disclosure from an inventor, an academic inventor in the universities, and then sits on it, works on it, writes it up, maybe wants to get more tests from the inventor, give me more enabling material from your lab test, and then files a priority application. Well, as you can see, half of these applications are filed, 3 months after they receive the disclosure, and a significant number even after a year. Now, what are all these applications that are filed so late? Well, at universities, I don't think it's that different than in startups and other places. It is a process of trying to get investments, trying to potentially get licensees, trying to find out if it's worth filing. These are real significant distributions. This is a case of about over 1,000 priority applications statistics. And so this is a real period that we use in the grace period, and that's essentially gone. It will have to change the behavior. These curves have to change. A lot of applications will not be filed or will just be filed prematurely. Under the AIA, at least 13% of inventions would be at risk of losing priority rights by more than a year. In other words, if they file, as they do now, a year after the invention, guess how many prior art sources can come in between those two dates, even though the invention date is earlier. Now, what does it mean? It means that if you actually look at applications that are filed based on having to achieve a certain date of filing, there's a very different behavior. This chart shows two columns. One of them shows the applications in the EPO that are first filing. Now, first filing in the EPO means an application that claims priority, that its first priority date is an EPO application date. A lot of EPO applications, in fact, claim priority from other nations or from other offices, so they're not first filing at the EPO. So this is not all EPO filings. What I see here in this column, these are all filings that are first filing, and they're only about 15% of all EPO applications are actual first filing. So this is a subset of applications, but it's important to show what happens when you're trying to file something that is based on the priority date is based on a filing date. The second column is the column of applications that are filed in the EPO that are second filing. In other words, they're claiming earlier priority, perhaps from another country or from an earlier EPO filing. There's no reason to hurry because the priority for that application is already established by the parent. But it's a good surrogate, a good indicator for what happens when you have more time to decide on the subject matter, to improve the application, and you have a mature application. You do not abandon it as often. In the EPO, first filings after first to file are abandoned 25% before even the search report comes in. Search report helps people resolve, yeah, I guess there's some prior art, I'm not going to do it. And even after first action, some will drop it. So look, 60% of applications made based on first to file pressure, not everything in the world is first to file, are essentially abandoned. Whereas only about, 11% or 12% are abandoned if they're not first filings. So this is an indication of the low yield, potential yield that one should expect in filing date priority pressures. What happened? Well, look at what happened in Canada. When Canada switched to first to file in 1989, there's a study by Abrams and Wagner on patent issued from those applications. And the share of individual inventors declined after 1989 by about 26%. In other words, when you compare the same effect in the U.S. during that time, there's no real significant change in the share of individual inventors. This is just how many of issued patents are issued to individual inventors. In the U.S., it was hovering between 15% to 20% or 18% during this period. In Canada, it went down significantly to about 9 or so percent or less. But the point is that this does have a real impact on individual inventors, more so than on large companies or large entities. The risks that are involved now are different, and we have to look at them in the new AIA in terms of where the opportunities and risk lie. So, for example, in the first to file, you would lose the grace period. You have Section 102 ambiguities. You're not sure whether PENOC and metallizing engineering are repealed. And you have prior user rights. Those are elements that come in and change the equation of how a patent system works. We have moved from a system in the U.S. Prior to the AIA that is centric about grace period and on the patentee, and moved to protect more secrets, more trade secrets, more user rights, and that move changes something. So, for example, if you compare two attributes of a patent system, the inventor's risks and the users, those who might be using technology of others or patented technologies, and you look at the trade-off between them. Our system today, in the first to invent with a grace period, provides some balance between inventor's risk and user risk. The inventor's risk relates to loss of priority, loss of claim protection, or loss of exclusivity, or losing trade secrecy in trying to essentially get a patent. The user risk may have to do with loss of right to use one's own invention, if you want to keep it a secret, or those which had long before been enjoyed by the public. Those are the two types of risk that we're looking at. This is a qualitative chart, and if you think about the bubble size being the size of disclosure we get from those types of patent systems, we have a fairly good disclosure in our system. The incentive to disclose is there, and the disclosure level is a reference point that we show by the size of the bubble. Moving to a first to file means we have higher investors' risks and even higher users' risk. Why is the investor risk higher? As you've just seen earlier, we may not be the one to file first, even though we invented first. We might have disclosed something. We might lose the patent. There may be a derivation that we can't prove. There are other elements in the first to file. We can't really reach back to any activities we've made. There's a higher risk to inventors in this area. But also there's a user risk, because a lot of users who may actually develop something and forego patenting and didn't really want to file for something, all of a sudden find that somebody patented and they can't really assert the prior user right as much. You can only do so in some business methods under the change in the Act of 1999. Point is that that is the reason why people pushed to say, look, first to file, we need to protect ourselves because, we may not be filing for applications. Yes, of course, they can diligently work through, and 102G saves them if they haven't abandoned or haven't suppressed their invention. They are still entitled to get a patent, but if they haven't pursued a patent, they have some higher risk. So therefore, people said, okay, let's come up with prior user right. That's a first to file. but we will reduce the user's risk because he has prior user right. And when you do that, you're trading off inventor's risk. And by the way, the first to file has a smaller ball because we're not disclosing as much. Remember, the quality disclosure is much. We don't do it when we vet things. We do it very quickly. We may not even file because we could see some risks. So there's less disclosure in terms of first to file. And by the way, you could see that in the size of disclosure sizes in the U.S.-based application versus foreign applications. There's some evidence showing that U.S.-based applications contain a lot more pages than foreign applications, but on average. But it probably is not only due to the best mode or some other enablement requirement, but it also has to do, I believe, with more time for people to disclose and to better support claims, which is related to the grace period. Going back to first to file and prior user right, we are now reducing the risk of the user because he can actually assert prior user defense. But guess what? He's not going to disclose. He's probably going to rely on it, a lot less disclosure. Inventors will see higher risks. Why? Because their exclusivity may not be really exclusive. They won't know who is hoarding a secret and who might be asserting prior user right. So now the risk of the inventor is high. They've disclosed something, they got a patent which may not really work against maybe the largest player in the market. Big risk, bigger risk. That is what happens with first to file and PUR. And we are therefore likely to see less disclosure under this regime, and that's why the ball is a little smaller. But is it really only first to file and PUR, or do we also have metallizing engineering being repealed? We don't know. The secret use that never bars a patent is what happens in Europe, for example, where there's no bar for getting a patent 10 years, 20 years. Frankly, if the secret use in metallizing engineering is repealed, Coca-Cola would actually be able to patent their trade secret that's been out there for over 100 years. And that's the example of evergreening some stuff. So there's higher risk to users, much higher risk to users who may be using these things for years, in secret, admittedly. But if somebody gets a patent all of a sudden because they have applied for a patent under some old secret commercial application, that puts a lot more at risk some other people. But it also increases, it does reduce the risk for inventors because they can decide to invent later. And so they can play the game of hoarding a secret for a while, invent later. So that's the situation. A lot less disclosure. There's a premium of hoarding a secret. So you can see that although we have ambiguity between the two, we don't know which one really is the operative regime under the AIA. Either balls are smaller than the first to file and grace period, and they're both, I contend, qualitatively at higher risk for both parties. But that's what happens when you deviate from the fundamental concept of a patent system. When you start mixing and matching all kinds of rights extraterrestrial to the patent system. Prior user rights, chipping away at some of the bargains, some of the exclusivities, and so on. Okay, last point on this issue is, does the AIA eliminate the need for first inventor determinations? That's what we've been told all the time. The push for the first to file was, look, we don't really want to make those factual determinations. That's why we're moving to first to file. We see the date on the application date and we know everything. Not true. Every derivation proceeding requires a determination of first inventor. Okay? Derivation is a question of fact. To prove derivation, you must establish prior conception and communication to the adverse claimant. I don't think that has changed under the AIA. Those are the tests that will be applied in derivation. And I cannot imagine a way to prove that somebody derived something from me without me having a burden of also showing that I invented it before them. Prior user right. If I'm going to use this defense, I better have a record that I have used it commercially a year before. Do I need also in commercial use to have some diligence? I don't know. It's not clear. The point is that the records of our use, which it probably involves, early commercial use probably involves elements related to invention, also require those records. So you would need to do that. The deadline of March 15th. It's not 16th, it's March 15th. Everything needs to be there by March 15. Caution is important here. Claiming a pre-March 16th priority, in other words, for a parent who was filed before March 16th, in continuations and divisions. The particularly important issue is the CIPs, but they're both applicable. First to file becomes reality on March 16th next year for all application, except for application where all the claims are entitled to an earlier priority date. One claim not awarded priority in a chain, essentially, poisons the entire application chain, even if that claim arguably is canceled, and even if a continuation is filed without that claim later on, as long as it relies in the chain that has a claim that at one time relied on priority that is later than March 15, 2013. Now, that may be a little bit threatening, as you might believe that if you're going to file a claim and the examiner finds that you don't have support or you have to cancel a claim. When canceling a claim, is that going to be a problem? Well, we read the statute and we filed comments with the PTO on this, that a claim that is unsupported at all, in other words, rejected by the examiner or has no support, doesn't have an effective filing date, and thus does not trigger the transition of the application chain to first to file regime. The important thing is to avoid declarations under proposed Rule 78 that would suggest reliance on priority dates that are after March 15th. If you know that you're claiming priority for a parent that is before then, being cautious in how you set up these declarations, if at all, is important. Caution is required. It's imperative that where possible, all applications which are expected to be prosecuted to be concluded before March 15th. Now, there's a very interesting window. The Patent Office is expecting to issue new fees March 1st. So there'll be an interesting window, potentially of 2 weeks. If you have micro entities filing, there'll be an opportunity to still file old cases in those 2 weeks prior to March 15th under the new fees, if the Patent Office gets those fees out in time, as it plans to on March 15th. In any event, be sure to make sure that you get your applications filed under the old law. That's the safest thing. There's a question earlier asked here about what happens if you have a continuation that claims priority prior to March 15th and is entitled to it under Section 102 and 103, but then comes to PGR, and Rob is saying he doesn't know the answer. I suspect that if you're within this region of the law, PGR may actually apply to any applications filed after March 15, unfortunately. So there could be a risk in terms of having two members of the same family governed by a different set of law in terms of priority. And so one would have to think about you know, if you're ever going to file an application claiming priority for from a parent before March 15th, you're going to expose yourself potentially to a PGR challenge on that one, and potentially claims or subject matter at that point to be challenged in a different regime, potentially threatening your parent or your other applications that are going to be governed under the law. So this is something to look for. I don't know the answer to that, but I would assume that there's some exposure there. There's some myths about first to file, and let's take a look at them. Under first to file, inventors would not have to keep corroborated invention records. Well, we already discussed that. It's not really true, as we showed earlier, but it's also important if you're going to deal with rely on something in derivation. If you have an employee or somebody who leaves and then you later assert derivation, how are you going to prove it? How would you prove it in state court? A lot of trade secret actions would have to be addressed in state court, and potentially discovery of material that can help you potentially in derivation may best be done through the state court system. So you have a hybrid scheme of using the judicial system in the states to affect discovery and bring it into the PTO and derivation proceedings. So there's a lot of interplay that have to be thought through in terms of those areas. Records have to be kept, if anything, be more meticulous in keeping those than before. Another myth: the first to file can be addressed by educating applicants to file provisional applications. Well, not really. The requirement for provisional application are basically no different from non-provisionals. When we file provisionals, we essentially plan for a non-provisional, we file claims, we do everything, and we file provisional only to save money and potentially get the 1-year patent term advantage, and also allow us, for example, to file a provisional application, then file a PCT a year later, designating the U.S., in that way entering the national phase in the U.S. and saving a U.S. application. There are some various strategies which provisional applications can be helpful and should be used. But it's not going to be solving the first to file pressure that we just discussed earlier. Provisional with no claims really is not something to look for, and we tell our friends, don't do it. Make sure you have information that is necessary. Some people use it more of a conception goalpost. That's okay, but don't kid yourself. Be cautious. And by the way, there's quite a bit of use of provisional application. They don't need to be educated. A lot of people do it. A lot of people use it. There's over 150,000 applications per year on provisional applications. What do we have to do in our companies when we get through this process? We have to get bi-weekly or monthly reviews. I mean, there's no real way to do it. Organized engineering organizations would have to do that. Now, not everybody will do it, but it would be important. Now, that doesn't mean you're going to file every month, but at least you will look to see if there's something that you need to file every month. For those of you who are outside counsel, outside patent attorneys, that's a challenge. Now you're going to have to educate your clients, you know, are they going to pay you every time you come there? Are they going to do it themselves? Are they have internal people to do it? I'll tell you, I've dealt with several companies here in the San Diego area and as advisor and so on. I asked them, do you do any of that? And they don't. Also asked them about trade secret. Does anybody in the company manage and identify what their trade secrets are? You'd be surprised, perhaps not, that there's no culture of documenting, having procedure for trade secrets, identifying them, and making those real decisions about how to deal with trade secrets compared to filing. This will be an important step here under the AIA. When an employee, a key employee, exits the company, what does that mean? He might be going to a competitor. Anything he's worked on, specifically on new technology and new inventions, do you have filings or not? If not, are you going to be at risk of potential derivation without ability to prove anything? That means you have to go and review whether you need to file. You probably have to put people out 2 weeks just to file things because he left. This is not insignificant threat for small entities. Exit procedures important to set up. Reassess protection under trade secret law, as I mentioned earlier. There are substantial risks. You need to have procedures to place, identify and document the trade secrets, and you also have to look at your schedule of issuance. You may be exposed for 9 months after issuance. Maybe you're going to have a cool period. Okay, that's a commercial practice. Maybe you don't promote your invention when your patent issues for 9 months or a year. The practice of a lot of companies is to issue press release. Oh, we just got this patent out, and so those may have to change. Lay low for 9 months. Who knows? A lot of things have to be reconsidered and re-implemented. Procedures have to be in place. Now, something that may affect you more than me as a manager of IP within a company, I'm not an outside counsel, I feel the workflow is going to change significantly. Delays in filing. There will be constant tension under first to file. Who is going to do what? How much is going to be blamed for delay in filing? Is the applicant didn't write enough material for the patent attorney? Patent attorney is going to be under pressure to get the stuff early, so it doesn't show that he's sat on it for 3 months. Will prior art be made? Are we going to file more IDS? Now there's about 92% of applications have IDS in them. 92%. Is that going to be like that in the future? Don't think so. It probably also means lower quality applications. That tension is who takes what part of this pre-filing period. Shifting responsibility. I expect, in our case, we do a lot of, I do a lot of our own effort, but outside attorneys would probably demand and should demand a lot more upfront written description by inventors. That means you will have less time during which your application is being written. You'd have less give and go, and you basically may have to set up your own thresholds as to the nature of disclosure and the nature of material that you want to get from applicants prior to you taking on the case. And by the way, this may be a positive thing because it's important to force inventors sometimes to put things in writing. They then think about it a little more, not just the design document, but also thinking about the claims and what they think they invented. Again, expectation here is that there will be more work having to be done on the side of the inventors to essentially protect yourself to some extent. As a result, you should have lower expectations. The inventors and the applicants should have lower expectations. There will be a lower yield process. More applications will be filed per ultimate grant. And the reason, as I showed earlier, is there. And it also means budgeting issues. It also means that they have to get ready for these things. And also means tough decisions as to which application to abandon, which one to not to abandon, and which to file. Invention ownership vigilance. There are now important elements about ownership disputes that are kind of worked through today by virtue of the fundamental fact that inventors are required to sign the oath, come high water or not. It is exposing, it brings to the fore any disputes on this issue. Inventors that are working with contractors as a contractor or work for hire or so on may not have all the full understanding between them and their client as to who owns what and who would file the invention, who would file the application. The new oath and declaration by the applicant, by the assignee or a party of interest, is going to generate a lot more issues. So for inventors, individual inventors, and people who work for hire, we know that we would need a lot more vigilance. Also, and you have a joint research or joint development agreements, and that's true in joint venture developments with startups and others. Again, some of these things may pop up, and all of a sudden you see an application filed, and the other element that is somewhat amazing, and frankly, I couldn't believe I saw it in the act, is that the Patent Office will now be able to take on and start examination and application with missing parts, meaning if there's no declaration or oath by the inventor, the Patent Office will essentially begin examining claims that nobody made. Think about it. The declaration by the inventor is the instrument of making the claim. I invented this, here's my claim. They will start examining claims that nobody made formally. Amazing to me, but now that's going to happen. Derivation, vigilance, you have to file a derivation within 1 year of the date of the first publication. So again, if somebody derives something for you, if there's an application or patent issued, you have to be on your toes. So the vigilance is going to be more important. To some extent, there was something like that interference, but you can have a broader window. You can start an interference earlier, but you got a little more leeway with interference. Frequently check the PTO published application online. So this is what to do. Again, the vigilance on the database. Now, the last element on this for startups is really, what does it mean for investors? And I've been talking to investors about the AIA and actually advised a couple of them on due diligence in some cases. And one of the things that comes up of that analysis is the following. The investors will look at this slightly differently. They'll have to think about the nature of the startups in a different way. If a startup depends on patent protection and whose invention development success depends on experimentation under public use scenario, it's an issue. So suppose you have an invention that is inherently applied in a public setting, okay, and you want to test it, you want to work with it. Well, do you have more risks now, especially if you don't know that you can do so under the AIA? Then you come as an investor and ask, well, did you file for an application? Guys say, well, I don't have money, or I didn't do it. I still have to try a few things. Again, an element of uncertainty, what it means to deal with that type of a company. Again, pilot production. Did somebody go out and require subcontracting out in pilot production? Think about the fact that the list of checks in a due diligence analysis by investors is now going to increase. There will also be reps and warranties that we as startups and people who are seeking funds going to have to make. Companies will now have to sift through the AIA when you make your representation and warranties and think about, am I being fully truthful by saying all these things, or do I now have to consider the AIA and the implications and all these laws? Okay. For example, Rob mentioned the issue of the supplemental examination. Okay. Now, in the reps and warranties, okay, how will I characterize a potential risk that could have been avoided with a supplemental examination? If I file one, if I file a supplemental examination, I now have to disclose it as part of the reps and warranties, and all the elements of characterizing it may become discoverable, may be an element that could attack my patents in the future. There's an interaction of governance within the corporation of how you raise funds, how you do things in the patent process. And I think that hasn't been adequately addressed, and nobody thought enough about this under the AIA. What are the practices of pilot production? Do you have procedures in place? I want to see a checklist. Do you have a checklist that says you can file for an application prior to issuing those pilot production or contractors, or not? Are you doing this? Investors today are advised to assume that there's no grace period under the AIA. It would be too risky for them to rely on legally uncertain lines as to when experimentation and reduction to practice ended. Large investment may be required for experimentation and for in-house activity, pilot production. If you truly need the additional time, investors may consider asking, you know what did it cost you to actually do this internally? Because we're not sure what it means to farm it out, and a lot of your development you may want to file later on. Tell us what it's going to cost. Again, a consideration. Whether they'll decide to ask to put more money in or require that it will be more money or not is yet to be seen. It will be a higher and riskier environment to invest in startups, totally different than what we have today. It may take several years for investors to kind of adapt to it, as companies adapt to it, but that is what I see some of the effects of this act. Okay, other questions up to here?
Any
Before I
questions
go to
here in the
the
audience?
fee setting.
None, Ron.
Okay. USPTO fee setting authority and the new fees, that is something that came more recently. We just had a notice of proposed rulemaking on that. But the AIA authorizes the Patent Office to set fees in Section 10 in order to recover the costs. Section 10 says that the recovery is for aggregate estimated cost, as opposed to Section 41, which I don't see it here. Yeah, it is here. Yeah, as opposed to Section 41D for other fees, which has the average cost of such processing. So the Section 41D2 criteria is for the particular service processing. For example, RCEs are now governed under 41D2, the cost for RCE, the fees for RCEs, and other things that are not otherwise specified in sections 41A through D1. So the USPTO interpreted this discretion pretty broadly, and I took some issue with that interpretation, as you'll see. General Counsel sent an opinion to PPAC, the Patent Public Advisory Committee, explaining that Section 10 permits any individual patent fee to be adjusted so as to encourage or discourage any particular service, as long as they meet the aggregate revenues for all patent fees. And that discretion is something the PTO believes it has under the Act. It then published an NPRM in September and proposed various fees, in part adjustable or set based on this interpretation of the discretion that it has. It then used the term, these fees are set for facilitating the effective administration of the patent system, really a euphemism for fees to, I believe, to suppress certain filings, or at least to curtail or to discourage filings of certain activities. What are those? Fees that will discourage particular services, whether intended or not. For example, for each independent claim in excess of 3, 68% increase in the fees. For each claim in excess of 20, 33% increase in the fees. Multiple dependent claims, 73% in the fees. For first RCE, 29%, but look at that. For second or subsequent RCE, request for continuing examination, 83%. That actually, I believe, deviates from 42D2, which requires that this be based on average cost of RCEs. So I can't see a difference between the two of them, but that's a separate matter. Appeal, it's going to be $3,000, 142% increase. In a typical application, I'm not sure this is easy to see, but the typical application, this table shows each of these components in what is essential patenting activity. So we don't have all the re-exam and all the other fees that are here. We don't have extension of time. All of those are not shown, but we're showing the major fees. And here, this is for a large entity table. And on this column, we have the average incidence per unit. So for example, filing, search, and examination, put them all together. Every application has to have that. Price goes up from $1,250 to $1,600. For each independent claim in excess of 3, there's half a claim in excess of 3 on average across all applications, including those that don't have more than 3 claims. And there's about 3.26 applications average in excess of 20 in average applications. So you assume these things, you put the average, and you get these increases. Request for examination, 55% of serialized application on large entity have RCEs now. And they are weighted between, 2 fees between $1,200 and $1,700, and so that's a weighted average of $1,350. The appeal now is broken up in 2. You used to file a notice of appeal for $620 and then an appeal brief, $620, and that was it. Well, now you're going to be filing $1,000 for a notice of appeal, even though you may never file an appeal brief. And you can see that, a significant fraction of notice of appeals are really not filed for the purpose of filing an appeal. It's just a placeholder to make a decision where you're going to file an RCE or an appeal. And a lot of times, maybe there's after final, maybe there's other things, but the timing requires that you do that. And the result, you now have to spend $1,000 just to do that, even if you don't file an appeal. And when you do file an appeal, you don't pay upon the filing of a brief, but you would pay upon it reaching the DPAI. It was taken by the board, $2,000. And so your total cost for appeal will be $3,000, but you may not incur all of it, and the frequency of occurrence, and that's the average. So on average, an application in the front end side, in other words, the part that goes through the prosecution before you get a grant and a patent issued, is going to rise by 37%. The backhand fees, which is maintenance and issue fee, will rise by only 21%. So you can see a fundamental skew where the patent office puts a higher increase in the front end and less at the back end. That to me is already indicative of an imbalance in terms of how to raise fees. But the patent office, I believe, is trying, as it says, to have an effective administration of the patent system, meaning discourage certain applications. The next slide shows what it would be for small entities and micro entity. Why the micro entity is going to be half the rate of a small entity. Not too many people will be able to qualify for micro entity. There are certain criteria for that, and people have a question, I can answer it, but the major difference is that every time you pay a fee as a micro entity, you'd have to reestablish the fact that you're entitled to micro entity fee, and so it's not just the application, but every time you pay a fee. That's different. And if you don't qualify, you immediately ratchet up to a large entity. In other words, you'd have to kind of go back and reclaim a small entity mode or something like that. So be cautious and look at the rules about the micro entity fee. Those rules, I think, came out in April or May, and I think they've all been issued. And the fee is now going to be decided on, hopefully, by 1st of March. The comment period for these things is closed. Unfortunately, we didn't have time to analyze a lot of the material that PTO has made, so a lot of our comments really are late. I have just written a paper on this issue about the USPTO fee setting authority in 2 parts, and it's been published in the BNA, first part today, and hopefully second part next week. If anybody needs a copy of it, I'll be happy to send you a reference to it. So that would be the small entity arrangements. Encouraging or discouraging any particular service is not really something the PTO can do, at least the way I read the statutes, other than the AIA and the Independent Officers Appropriations Act, under which PTO has no deference, because this is an act that is administered broadly, and the courts really have jurisdiction on interpreting it, not agencies. And that basically prescribes setting fees to encourage or discourage any particular service. Using fees to encourage or discourage a particular activity is a tax that requires an explicit delegation from Congress, a delegation the PTO did not receive under the AIA. There is some case law under the IOAA explaining specifically that such policy decisions whereby an agency could, for example, adjust assessments to encourage or discourage a particular activity would, according to the Supreme Court in NCTA 1974, carry the agency far from its customary orbit and infringe on Congress's exclusive power to levy taxes. If a particular activity is to be discouraged through fees, it needs to be authorized expressly by Congress. None was essentially, no such authority could be read in the AIA. The optimal approach then is for the office not to test the envelope of its discretion, but rather use a legally safe fee structure for the USPTO. Set fees for items governed by 41D2 based on average cost. That's what 41D2 says, and that term, that 41D2, doesn't have a timing. It says that's how you set it. Even if you adjust fees, you set it, you adjust it based on cost. So, for example, don't set the RCEs in 2 different rates. It doesn't work. It doesn't comply with 41D2. Even when Section 10 says you can adjust any fee, you ought to do it in consistency with 41D2 while maintaining the aggregate cost. And you have enough degrees of freedom to do that by simply scaling all fees according to the policy that Congress has established, and all the statutory fees from 41A to 41D1. That's the approach which enables the PTO to capture its cost based on the aggregate estimated cost while not encroaching into policy matters. Those policy matters establish the ratios between front to back. They establish the relative ratio for excess claims, things like that. So that is basically the last item on the fees. This concludes my presentation. If there are any questions, I'll take them. I know I'm a minute over the time.
Is there anyone here in the audience that has a question for Ron? I've got a general comment for everybody listening. I'm going to teach you an acronym, JBR. I'm watching everybody in the audience, and everyone, I think after Rob's presentation, half the wind came out and the rest just came out. There's a lot of analytics in what Ron has done. I'd encourage you to look at his publication in DNA today and next Friday. You need to take this presentation, you need to save it. JBR is just blame Ron. You're going to have to sit down with your clients, you're going to have to sit down with your management committee, and you're going to have to explain why things are more complicated and more costly. And I think that some of the things that Ron's done are very helpful, and you picking this up and explaining to your clients or explaining to your boss why you need to make adjustments in the business plan that your client or the entity you're representing is implementing. And so there's a lot of value in that, and I'd encourage you to save Ron's presentation. I'm sure if you have any questions, you send him an email. He's extremely attentive, and he'll help address any of your questions or concerns.
Thanks, Keith, and thank you, Ron, for that great presentation. So we're going to break for lunch. We're going to reconvene at 1:30. For the folks here in Seattle, we have lunch set up for you just around the corner to as you exit to the right over there. You can pick up lunch there and bring it back here to eat if you'd like, or continue to network, stand around and eat if you'd like around there at the lunch station. And again, we're going to reconvene at 1:30. A couple of people previous